Exactly. But I filed a injunction petition on 6-5 mailer, appellant mailer, RSA mailer. Appellant having lost mailer, I think the land mailer and construct house here. Injunction petition.
When?
Mailer, any date mailer.
Okay, on 5th.
Your Lordship. Sir, Prayer Lordship, I have also filed an injunction petition in an appeal Lordship that is on 27/5. Can it be on 4th Lordship?
Hmm?
4th Lordship?
No.
Next to date Lord.
Not 4th.
They have already started some construction Lordship.
Can't help it. On 5th. You
5th.
filed it on 27. Why didn't you say, mention it? I can't impose upon the another judge who is coming up into the bench so much.
And Lordship, one more thing, Lordship, in one another, this Lordship on 5th, I'm writing.
5th.
Yes, Lordship. And another matter, Lordship, order matters. We have filed one substitutions. Lordship, we made a mistake. Instead of appellant number 13, we have written appellant number 12, Lordship. And thereafter order was passed, Lordship. So for correction of that, we have filed one IA. So that may kindly be listed because in the meantime, some other respondent also died. We are required to file substitution.
When?
Any date, Lordship, next week.
Okay. 12th.
Of like.
Just to mention item number 3, Lordship. Angus Council is busy in his Angus Council is busy in his mother's statement.
Who?
I Hassan, Angus Council.
Okay. The request of the learned counsel for the petitioner. Matters stand adjourned to be listed after 2 weeks.
Please, Your Lordship, I beg to mention item number 34, my lord. So the matter become infructuous now, my lord. That guardianship matter, my lord.
Item number?
34, my lord.
Mr. G. Alam, the learned counsel, appearing on behalf of the petitioner, submits that in view of the fact that the learned trial court have already decided that the trial court did not have the jurisdiction, nothing further remains in the instant proceedings. Accordingly, he submits that he may be permitted to withdraw the instant proceedings. Taking into account the above, the instant proceedings stands closed on withdrawal.
Obliged, ma'am.
Your Lordship, I filed IA. In connection with the item number 22. Yesterday, that I may be allowed to take up with during course of the day. I may be take up with the item number 22. There is state of further proceeding. The title suit has been pending before the learned civil judge Kamrupat Guwahati in connection with the appeal. That matter has been proceeded with. The learned civil judge senior division number 3 said that is being a stay order from the Honorable High Court.
How can this court stay that?
Closely related with the proceeding.
So what?
That's why I'm filing.
Wait, proceedings and suit, these proceedings are different.
Yes.
Then- Anyways,
I may be allowed.
at the request of Mr. L.K. Bora, the learned counsel submits that an application has been filed in the instant proceedings. List the matter on 7th of June 2024 along with the said application.
Your Lordship, I'm praying for listing of the matter, Your Lordship. A regular second appeal, Your Lordship. For admission, Your Lordship.
Admission?
Yes, Your
Why?
Lordship. Because there is in this application there is an injunction application which is connected, Your Lordship.
It has not been admitted.
Yes, Lordship, I think so. Yes, Your Lordship. It's not been.
You think. Your thinking would not do. Find out and mention it on Monday.
Your Lordship, kindly can it be taken out?
Absolutely no. Monday. Nothing new.
Item number 9. This S Roy can be taken up on some other day, Lordship.
Which one?
Item number 9, Lordship.
9.
Yes.
Who are you?
About Mrs. S Roy, appellant, Lordship.
He's not there. F. Begum, P. Dasgupta, S. Paul,
It's supposed to be argued by Mrs. S. Supposed to argue by Mrs. S.
none are there. Okay.
His lordship
At the request of the learned counsel for the appellant, matter stands adjourned to be listed after the summer vacations.
obliged.
Yes, what is that order you are challenging? Who has filed CRP?
If I.
Yes, what is that order?
The appellate court had reversed the order of injunction passed in my favor by the trial court, which is why we are here, my lord. My lord, the dispute is among two brothers, my lord. There was 2 kotha 8 lechas of land. We say that two out of those 2 kotha 8 lechas, 1 kotha 1 lecha was occupied by each of them, and there was a passage between the two plots where 5.5 lechas was consumed. So that is how 2 kotha 8 lechas was taken up. Now, their case is that as in the resettlement operation, there was an increase in the quantum of land, which is why they are in possession of 1 kotha 5 lechas. Now, Lord, we allege that encroaching upon this path, they have started a construction and construction of a multi-storied building. And contrary, I took my instructions today, contrary to what was submitted on the last day, that it's a residential building. In fact, it's a commercial cum residential.
It appears from the photograph. But whatever may be, the construction has already started. The trespass has already happened. Now, they have made a part of it. Some portion, because we are only in respect to the suit part. How much is the suit part? 5.5 lessers. How much they have encroached?
Lord, in fact, there was a commission. I was coming to that. Lord. Ideally, my lord, yes, I would go with that proposition that at this stage of constructions, injunctions should not.
No, it is not only the question of construction, it is a question of the trespass has already happened.
Trespass has already happened, my lord.
And as per, and not only that, construction have already been done. If they have already made it and have raised on the last occasion, I saw a photograph which the senior counsel have shown. The construction has already been made. 2-3 floors, they have already raised it out there. Now they have given an undertaking to the effect that if the suit goes against them, then they would demolish that portion of it. So why?
Ideally, yes, my lord, but here the problem is, my lord, they have obtained the permission. As per, they have violated their own plan, and that is apparent from the commission.
Go to the GMC.
The GMC has already furnished a report.
Understood.
Has 107
Don't know. Forget about that. Is the GMC not capable of? Go to the GMC, ask them to break it.
Municipal authorities are not intervening because the suit is pending.
Okay, I make it clear. If there is a the violation out there, you are at liberty to obtain and
And another development that has happened because of the constructions that have gone on, my lord. Now, my lord, my boundary wall has also collapsed. If your lordship will take up the additional affidavit, my lord. Additional affidavit which was filed. If your lordship
the boundary wall has already collapsed.
and that is my access path, my lord. That's the difficulty.
But how do you want the suit now? Once I would have understood if this were just putting the plinth out there, this court could have done something so that something remedial measures could have been taken. But as of now, where the construction has already been done, can without a final decree, any demolition to that effect can be made? No.
But here again, there was a status quo in the midst, my lord. That was, of course, vacated. So, if this injunction remains, we may explore the possibility of preferring a application for mandatory injunction. But 154 for a moment, if your lordship see.
Mandatory injunction is
154, if your lordship see.
What is that?
That there was a path is not in dispute. That the original quantum was 2 got height lectures is also not in dispute. But this is the access path, Manoj. Now,
Which is the access path?
Manoj, where the wall has 154, Manoj.
Hmm.
This is the entry, Manoj.
Hmm.
There was a gate there. And now, my lord, if your lordship sees 107 for a moment
Hmm.
of my petition, my lord. It's 120.
Now come to 156. Your building is where?
Behind this,
The white one?
156. No, my lord, not the white one. It is behind this.
Behind this, there is a Assam type house.
Yes, that is my.
Then why you are not showing that picture out there? That picture is not there.
That picture is available, my lord. I'll just show.
Huh?
That picture, those pictures are available in the IA for state.
Page 153.
120.
Page 153. Is that the document? Page 153.
153 is from the front portion. my lord.
Down below.
Yes.
Wait.
That's the.
Because your houses would be this one.
Yes.
And then there is this
We've
particular.
got a clear color picture, my lord.
Oh,
The Assam type house.
We'll take up.
this is also colored.
Oh,
Copies are.
Cabo.
Page 35 of the IA, your lordship will also see.
Yeah, I could also. Yes.
Your lordship sees the gate, my lord, and the wall. That wall has collapsed now because of the construction.
That wall.
Yes. There's a thin gate. my lord. Now, all this was.
How do you go inside?
That is the problem, my lord. There's just a narrow passage left now. Now that the wall has also collapsed, my lord. My lord, 107, the commission report.
No,
of
no.
the
How
lordship
much was the breadth of the passage?
breadth was 5 feet. 4 to 5.
You must have given it out there in your plane.
Yes, I-
What is the breadth of the passage?
Schedule C, my lord, of the plane, page 36, my lord. 4 feet by 4 feet, my lord.
4 feet?
Yes.
So it is now what?
Now
2
it's
feet.
Now it's reduced to, this is the 4 feet has been encroached. This is the encroached portion.
No, how much it is now?
That will, the original,
It is only 4 feet.
4 feet by 200.
Where is the where is the by 4 feet?
My lord is having page 36.
Page 56.
56 is their schedule. That's the schedule of the counter claim.
Huh?
That's the schedule of the counter claim. Page 56 is the schedule in the counter claim.
So then also it is 4 feet by 100 feet.
Yes. Their schedule C.
That is your schedule. So it is 4 feet by width. The width is 4 feet and the 100 feet is the length.
Yes.
So it is 4 feet. Now how much it is?
My lord, it's that is clear from 107. $107 is the inspection report.
Who has made this?
This is by the assistant engineer, Gwalpara Municipal Board. Now, my lord, 109, they have depicted the setbacks that were permitted and the setbacks that are actually on the ground. Page 109.
So now there is 2 feet.
2 feet. They should have ideally maintained 9.84 feet. They've just maintained 2.79.
Huh?
Page 109.
This is what 108.
108 is rare setback.
Their setback should have been how much?
9.48.
9.48 feet. Now they have made
Page 109, 2.79.
is the 2.
Page 109. It's part of the inspection report.
So they have and
So it is not even as per the plan, their own plan. Given all of this, we are saying that. the-
Mr. Chaudhary, where is your permission?
Permission from the permission, my lord, today we have. Today we don't have. My lord, can I just have your lordship's kind attention to page 120 for a moment? Now let us see, my lord, the injunction which was given in their favor. What does it say? Page 120. A part of Schedule A land measuring 4 lacha, which consists of a land of a common path measuring 4 feet by 100 feet, and a small northern part of Schedule B land, that is just in front of that Assam Tribe house and behind our construction. So far as the part of the suit land measuring 4 feet by 10 feet, 100 feet it should be, both parties categorically admitted there is 8 feet wide road exists in between the land of both the parties on this one side and land of their uncle Abdul Razak Sikdar on the other side. So determination of said suit land is not disputed and no further discussion in this regard is felt necessary at this stage. The road exists, my lord. Dispute is only regarding a small northern part of the Schedule B land that is end of our construction and in front of their Assam Tribe. So this is the injunction order they obtained. Now my learned friend is going beyond that. So as far as the road is concerned, my lord, we have given a sketch map in our affidavit. If your lordship will
No,
kindly
no,
have
they
that.
say both the parties categorically admit that
Yes.
there is a 8 feet road.
Huh.
Now, is there a 8 feet road?
8 feet means 4 feet, 4 feet is from our side, my lord, from both sides.
Yeah, maybe.
No, huh.
The map will be clear.
My lord, the-
Maybe.
huh.
But as of now, if you see the inspection report, it
Yes.
is less than that. And that inspection report, you have not cross-examined the witness.
My lord, with your lordship's kind permission, my learned friend is thorough with the facts, if your lordship permit.
Yes.
That is the Kensington Royal Court,
Of course,
my lord.
Tell me.
My lord, as far as the maintenance
Yeah,
of
people
the
are-
provisions of the municipal building permission is concerned, we have out and out carried out the building permission that was granted to us, except on the so-called northern side of the Schedule B land, that is the land of the petitioner. That is, the land of the petitioner and the respondent is rectangular shape. In between them, there is a wall, existing wall. This particular and material fact has been concealed by the petitioner in the title suit. Nowhere in the title suit nor in the injunction petition has he mentioned that there is a boundary wall between these two, that is between the parties, I mean the petitioner and the respondent. This material fact was hammered upon in the learned trial court also, in the appellate court also, but the factum was not properly given emphasized. But this factum has been clear from the municipal report that has been obtained. And that
Whose
is
boundary wall it was?
boundary wall between the land of the petitioner and the respondent.
So
There is a
whose,
precise boundary wall.
whose boundary wall?
Boundary wall was forcibly constructed about 15 years back by the respondent himself, I mean petitioner himself. Although we have entitlement of land within his boundaries, he has got excess land in his illegal possession. About 15 years back, he forcibly constructed the boundary wall in between the land of the petitioner and the respondent. And on objection, he said that when we shall carry out construction in future, we shall mutually decide the boundary between us. The entitlement is total entitlement of both the brothers is 48 lesser. So actually, it has to be divided by 2, and the share, individual share, stands at 24 lessers. How come that they say that the entitlement is 1.1 lesser? This can never be. Number one. Number two, there is a precise wall between the land of the petitioner and the respondent. And we have constructed the building well within the established possessory area and not beyond. And on all sides, we have maintained the municipal provisions of building bylaws. But
Just
except-
one,
my lord,
the boundary wall was there.
boundary wall was existing.
So your part was beyond the boundary wall, inside. So when the boundary wall fell on the other side, or where this side or where, it may have been that they did not maintain a setback from the boundary wall
Yes.
to their building. That's
Yes.
another thing. But
Yes.
would it amount to encroachment to their land?
No.
And it's like that. So what is happening here is, total land was 2.8
No, I'm not on that.
Well, that's
I'm not on
what-
that. But unless you are asking, there is a boundary wall,
Yes,
and you say now the boundary wall has fallen during the pendency of the instant proceedings. Because of that, you have filed this additional affidavit. Now, once the boundary wall has fallen, meaning thereby your suit path or your path by which you wanted to go was beyond the boundary wall, and his construction is
it's encroaching upon part of the common path, Manoj.
no, it could not have been.
No.
Because you have a boundary wall.
Boundary wall is here. The path was beyond that. They encroached upon the.
No. Are you saying when your land and his land is divided by a boundary wall or not?
Divided by a boundary wall and a common passage in between.
Common passage is in which side?
Oh, to my north, Manoj. And to
Beyond the boundary
on the
wall
express-
towards his land?
Not towards it.
Towards it. Then how did you enter from there? If there was a boundary wall.
Boundary wall and a gate. I've shown the photograph.
No, there is no gate.
There's a gate, Manoj. I've shown the
No gate.
photograph.
You are saying about the team gate.
That is my entry point, along with a boundary wall, and there's a passage in between. Now, since they pushed this side, encroached upon a portion of the path, Manoj, therefore, because of the digging, my boundary wall has fallen. And that 8 feet path, if I may just clarify, that is on the east, Manoj. That's a different path, which separates the land of our father and our uncle, Manoj. Manoj will see
That is the white building.
the white bill. My lord will see
In
their
between the
own
white building.
affidavit. My lord will see their own affidavit at page 46 in the I.
Yes.
Now, my lord, this is the 8 feet path, my lord, that we are not concerned with. That is the 8 feet path dividing the land of our father and our uncle. Abdul Razak Sikdar, your lordship, fine. That's the land of the uncle. Now, this is the common path of 8 feet, the broad path. And from there, your lordship finds an arrow, and it is shown as Schedule C suit land. It is their document.
So this is the arrow.
This
It
is
goes
the
to
encroached portion.
which one?
This portion. My lord sees an arrow there.
Partition boundary wall.
Yes. Partition, boundary wall, and then Schedule C suit land.
So you mean to say you tried to enter
I was
from
already-
his land,
Yes.
from his portion beyond the boundary wall,
Yes.
you used to enter.
Yes.
You have a
Yes.
easementary right over
Yes,
that.
in easementary right, in the sense it was a common path, and
No,
it
it
was
couldn't
part
have
of-
been common path. You see, the path is beyond the boundary wall.
Right.
So is it your case that beyond the boundary wall is your land?
No. This entire portion is 2.
This is understood. There is a boundary wall. Down below to the south is your land.
Yes.
To the north is his land.
In between, there's a
Boundary wall. Now, do you admit that the land beyond the boundary wall towards the south is yours?
yes.
And the land beyond the boundary wall towards the north is his?
After the path. After the path.
There's no path there. How can there be a path? Meaning, if this is his land,
No, there was a
No
path
path.
in between.
then why did you have a boundary wall?
And I agree, my lord. There's a
So you have to enter through his boundary wall, through his land.
No, my lord. Lord, his land is on the north, my land is
Understood.
on the south. Between there is a passage of 4 feet, my lord. From that passage, I enter, and there is a boundary wall and a gate. There was. Now they have built a building there, which is why
Then whose land is that?
that is our land, and had an arrangement that we will maintain this particular 4 feet, which consume 5.5 lechas out of the total 2.8 lechas.
That is oral.
That is oral. There was a will, Manoj, they disputed, but that is the arrangement we had. Para 5 of my plaint, I had said that.
Yeah, you have stated that, but as of now, there was a boundary. Why did you put that boundary wall at all then?
That's my boundary, my lord. That's my boundary.
So that is not your land, therefore, the other portion.
The other portion, there's the common path, and then beyond that is their portion, my lord. And that is the arrangement we had, my lord. And in fact, in the written statement and counterclaim also, they admit, they do not dispute that there was a common passage, my lord.
Was it
And-
beyond the boundary wall?
Beyond my boundary wall, yes.
There was a common
There
passage.
was a common passage, and they say basically that we have encroached more land. So there.
No, that is a different thing. Did they accept in their written statement that that was beyond towards the north of the boundary wall, the common passage?
I'll just refer to their written statement, my lord.
Why do they say that the common passage was beyond the boundary wall?
That specifically is
That
not
is
just-
that is the crutch.
That is the crux of the case.
My lord will see. that
Otherwise,
if-
there is no point in dividing with a boundary wall.
My lord will see my paragraph 5 for a moment and then their response to it. Page 25 is the plain. Page 29, paragraph 5, if your lordship takes up. Page 29, my lord, paragraph 5.
Yes, what does it say?
That on mutual family settlement, the said 2 kotha 8 lechas of land was divided in terms of the will deed, and the land measuring 4 feet breadth and 200 feet length, that is 5.5 lechas, went for common Yajmali path. Land measuring 25 feet breadth and 100 feet length, that is more or less-
29 feet breadth and 100 feet length. That is
that
more
is
than
more or
one
less
kotha
one
went
kotha, one
to the
lechas
defendant.
went to the defendant number 1, which is the frontal part, and land measuring 29 feet breadth and 100 feet length, that is more or less one kotha, one lechas, fell in the share of the plaintiff, which is the backside of the share of the defendant. Then subsequently, then this is how the problem began. You know. That subsequently, the land measuring 2 kotha 8 lechas was placed under new DAG number 1011 of Kheraj Miyadi Patta number so and so, but area of the land was erroneously recorded as 3 kotha 1 lechas instead of 2 kotha 8 lechas in the name of Abdul Sattar Sikdar.
Who is Abdul Sakar Siddhar? Okay.
Father of both the parties. Similarly, the land measuring 2 kotha 12 lechas was placed under so and so in the name of Abdul Razak Siddhar, that's the uncle. That as per the terms of the registered will and subsequent family settlement deed, the share of the plaintiff and his elder brother, defendant number 1, stood at 29 feet breadth and 100 feet length, measuring more or less 1 kotha 1 lechas, but the defendant number 1, in collusion with the revenue staff, behind the back of the plaintiff and the pro forma defendant number so and so, without serving any notice, upon the secretly and fraudulently recorded his name in the revenue record to the extent of 1 kotha 5 lechas, therefore 4 lecha excess land, which he was not entitled.
Where is the mention of a boundary wall in your
Boundary wall-
plain?
Boundary wall I have not.
Then
Oh, no, that's my boundary. And
why you have not mentioned that there is a boundary wall? Beyond that boundary wall, that land is there. The suit path was there. Where is your mention?
say that it is bounded by a wall.
Where have you mentioned that
I
it
not
is?
said.
No, you have not mentioned in your schedule also that it is beyond the that the boundary that the suit path is beyond the boundary wall. Where have you mentioned that? Tell me.
I am just saying, my lord. That this
No,
is-
that is a very important thing. Otherwise, this court would not have known about this boundary wall unless you have filed that additional affidavit. Now, additional affidavit shows that there is a boundary wall. And did any of the courts consider that there is a boundary wall? Whereby your land is completely segregated out.
My land is completely segregated, which I have described already.
Yes. So the question is about the suit path. So
Suit path.
where you say that it is beyond, but there is no mention that your land is completely bounded by a boundary wall on the north and the suit land and the
I
suit
have-
part
I have said-
is beyond the boundary wall. Why
I
didn't you
have-
mention?
I have one kotha, one lakh has 29 and 100 feet, my lord, and he has 29 and 100 feet, and between that, there is a.
We have how much is not concerned. But the question is, you say that this is what it is. You say that 2,900 square feet is your area. That is your case. Your area is 2,900 square feet.
Yes.
100 into 29 is 2,900 square feet.
Ah.
So that is where you have built your house.
Yes.
Now, that boundary wall was made. Why there is no mention that the boundary wall, because it would have been more specific then. Your schedule is not correct. Your schedule should have been made clear that there is a boundary wall and it is to the north of the boundary wall. Because once you bring the concept of a boundary wall, which it also shows that your entitlement out there would be this, and thereupon the beyond what will happen. Now, what is the injunction which have been passed by this court, Mr. Chaudhary?
Yes, yes. Injunction is at page 120, my lord. Oh, this honorable court.
Yes,
No
this court,
construction.
this court. Yes, what order has been passed?
The original order by the trial. High Court order.
No construction,
Yes.
the entire building.
Yes.
You are only concerned on the backside.
Yes.
Why
Four
the
less, sir.
entire
My
building?
lord, if it can be segregated in that fashion, I have no objection.
Then-
You should not come to the.
And it is not even full day, sir.
Not to my knowledge.
Not even full.
My anxiety is only their back, the rear portion. They do whatever they.
And what is the position now at the backside? What is the backside construction?
The backside construction, the building has come till the back.
No, how much?
No description, sir.
How much is the construction on the backside?
4 lectures I've said. Hey, your lordship,
Where is the photograph of the backside construction? Mr. Chaudhary, you have a photograph of the backside construction?
Yes. Move photo from there now.
Clear picture. This is the clear picture.
No. Or sometime.
Eight.
Reply. Reply to. Reply to.
What's my Wait. এখন এখনটা
The construction has gone up. Then what is there? What to do now? You want what? What do you want now? Why to stop this construction? He has already given an undertaking. If you win the case, get it.
that is fine. Only thing is, my lord,
Page
it also
96.
violates their own permit, my lord. And
If it is violates the permit, there is an authority go
my
there.
lord, I've made that, my lord, that the authorities in view of the pendency is not because.
I make it clear.
My lord will observe that.
We dispose of the matter.
Fine.
And no alienation, because this is a commercial residential.
residential come
No,
commercial.
residential.
No, alienation so done
Oh,
shall be subject to the outcome of the,
Yeah.
Restrict at least the alienation.
no, shall be subject to the outcome of the
Yes,
suit.
yes.
Well, that goes without saying.
No, not only that. Then
But
then the burden is a huge burden. Tomorrow, if it has to be broken, then this alienation or alienation will be those subject. And as of now, he says that there is no alienation. So we make,
My lord will record that.
we'll record it that there is no alienation. So any alienation so made shall be subject to the
And
outcome of the.
constructions also remain subject. Only thing is, the municipal board may take action.
Absolutely
Well,
no.
I can approach.
Yeah, that is a different thing.
My lord said that, my lord, to clarify to that extent. If I may, my lord, just one thing, my lord.
No more things.
Let them-
Enough. All things are over.
Let them go ahead with the construction, my lord. If your lordship, the constructions remain subject to given the stage of construction, my lord. Only thing, third party rights, if they are created, my lord, I'll have a tough time again, my lord. Because apparently, the report also shows, my lord, they have not maintained the setback. my lord. Now,
They have not maintained the setback in their land. Remember, as per the report, the setback has to be there in their land.
Precisely, my lord. He said.
No, kindly, no, Mr. Dekar, kindly appreciate. When a setback is given on the north side, east side, south side, or whatever may be, it is presupposed the setback is within their land. And the report says that there is a setback of 2.79 feet. So under such circumstances, they may have made certain mistakes as insofar as the GMC authorities or whoever, the municipal authorities who have granted the permission. But it may not have any relation to you.
My lord, why it will have, I'll just clarify. my lord.
No more.
My lord, we'll see.
There is, we know it is summers now, the Supreme Court is closed. Thereafter, you please go there. In the month of July 7th, it is
My
open.
lord, they have, the report says, my lord, I agreed, my lord, the setback is from my
Lefok. This is an application under 227 of the Constitution challenging the order dated.
The lordship's kind permission.
Yes. Order dated 27/3/2024, passed by the Court of the Additional District Judge Gwalpara in Miss Appeal number 06/2023, whereby the learned First Appellate Court had set aside the order of temporary injunction dated 21/8/2023, passed by the learned Civil Judge Senior Division Gwalpara in Mizze case number 29/2023, arising out of title suit number 34/2023. What is that last line of that order? The judgment has been correctly recorded and typed by Amanonesis. What is that? Any idea? What does it mean? By this?
Last part of the operative part of the one.
The last line of that order?
That is appellate order.
That order.
Last line of the order is.
A literary or artistic assistant, in particular one who takes dictations or copies manuscripts.
Beautiful name for a stenographer.
For the purpose of deciding the legality and deciding as to whether the First Appellate Court was within its jurisdiction to interfere with the order passed by the learned trial court, this court would like to take note of the facts which led to the filing of the instant proceedings. The petitioner herein, as plaintiff, had instituted a suit claiming inter alia that a plot of land measuring 2 kata 8 lechas originally belonged to the father of both the plaintiff as well as the respondent number one. The plaintiff as well as the defendant number one. Upon the death of their father, it was mutually agreed that the brothers, that is the plaintiff and the defendant number one, would accept, would remain in, would claim rights in respect of 1 katha, 1 lecha of land each. And the remaining 6 lechas, 5.5 lechas, and the remaining around 6 lechas of land would be a suit path This suit path have been specifically described in Schedule C to the plaint. During the in the instant proceedings, a further interesting aspect has come into light, which is not a part of the plaint or the written statement, or for that matter, written statement. Inasmuch as it appears that there was a boundary wall.
Begging pardon.
Statement we
Begging
have said
begging
there is
pardon. We have taken up the
In
fifth
the
row.
instant proceedings, an important aspect have been duly admitted by the plaintiff, that there was a boundary wall encompassing a boundary wall on the northern side of the plaintiff's land, abutting the land of the defendant, number 1, which was also the specific case of the defendant, number 1, in the written statement. This aspect came into light upon filing of an additional affidavit, bringing to the notice of the court that in view of the construction raised by the defendant, number 1, the boundary wall had fallen. The dispute between the plaintiff and the defendant, number 1, is primarily the Schedule C land, as to, or for that matter, as to whether there exists a common path beyond the boundary wall, or for that matter, beyond the boundary wall on the northern side of the plaintiff's land. It is also seen that along with the plaint, that in the suit, the plaintiff have sought for various reliefs as regards declaration of his right, title, and interest over the suit land, that is Schedule B. Schedule B, na? Schedule B.
C. Cannot be lordship Schedule C.
Huh?
Schedule C.
Schedule C,
Yes, that's the vague land.
which is the suit land.
Schedule C.
Schedule B is my land.
And
Schedule
Schedule C.
You are asking for declaration of what right?
I'm asking for declaration that.
Page
or
36 may be
36
perused, Schedule C. Schedule C may be perused once.
That I have seen it. Now, what he's asking for declaration, what is the soup land? Let us see.
Schedule B is my land, my lord.
Schedule B is his land and
Schedule C is the
See,
land that they will.
where do they say which is the scheduled land?
35 onwards.
Now, where is the scheduled land?
Is 35.
35 onwards the schedule is there.
Ah. Now, how can you ask for
They're asking for Schedule C land.
scheduled C land?
I'm asking
Declaration?
for schedule B, my lord. There's some.
Schedule B is their land.
No. Kindly see page 31.
34.
31, page 31, paragraph 8, the last line.
They said aforesaid excess land is schedule C.
No, the aforesaid excess 4 letters of
letters,
land
what is
incorporated in the sale deed is the suit land
Yes.
shown in schedule C.
Schedule C.
Meaning thereby what?
Schedule C is the.
Schedule C is the suit land. Now you are asking for declaration of the schedule C land.
Yes.
How? Isn't that the common path as per you?
Schedule C, I've said that common path and a small portion of schedule B. That's the encroachment according.
No. You say, you kindly see this, paragraph 31, page
Yes.
31.
Yes, my lord.
The aforesaid excess 4 letters of land incorporated in man is the suit land shown in schedule C of at the foot of the plaint.
Yes. And para 8 on top, my lord, under that very same paragraph, was entitled to get more or less 1 kotha 1 lechas, but he fraudulently recorded his name in respect of 1 kotha 5
No,
lechas.
this is the 4 letters of land.
Which includes the land of the common path and a part of.
How do you have 4 letters? 4 letters, wasn't it common amongst both of you?
That is the dispute, my lord. What-
How can you ask for declaration of your right title and interest in respect to that? You can't ask for declaration of right title and interest of that, then the entire
Sir,
suit land.
This 4
If
lechas.
your specific case is that look here, 1 katha 1 letter I have kept, 1 katha 1 letter he has kept, and the remaining we have just used it for as common purpose. So how are you saying that remaining is how much?
That is what I wanted to find out. For our cases, 1 kotha 1 lecha, they should get, they also admit 2 kotha 8 lecha is total land. Then they say there has been an increase in the land, and on that pretext, the father sells it to the son. 1 kotha 5 lecha. And therefore, we are saying that this excess 4 lechas which you mutated is a part of the common path and some portion of.
Therefore, if it is a common path, then how can you ask
Well,
for
the
declaration?
prayer
That
should
is
have-
my answer, question.
Prayer should have been, my lord, for declaration that it's a common path and.
For declaration of his right title and interest over the suit land. Though at paragraph number 5 and 6 of the plain, it has been categorically mentioned, it is the categorical case of the plaintiff that this suit land is a common part between common land between the plaintiff and the defendant number 1. In addition to that, the plaintiff have challenged the deed of sale executed by the defendant number 1 in favor of the defendant number 2 on the ground that these 4 letters of land, which forms the schedule C land, was sold by the defendant number 1 to the defendant number 2 by the said sale deed. In addition to that, the plaintiffs have also sought for various directions upon the I have also sought for permanent injunction and also for correction of records. It is, however, interesting to mention that although the Goalpara Municipal Authority have been made a party to the said proceedings, there has been no relief sought for against the said municipal body. The defendants filed their written statement. Some counterclaim. denying the case of the plaintiff? Footstep. It is, however, interesting to mention that in the counterclaim, the land owned by the father of the plaintiff and the defendant number 1 was stated to be 3 kathas, 1 lecha, and has been specifically described in Schedule A. It was also mentioned that the plaintiff have encroached upon 5.5 lechas of land, including a portion of the 4-foot width road, land of common passage. And as such, have sought for declaration that the counterclaimant number 1 had every right, title, and interest in respect to the Schedule D 5.5 lessors excess land, and for recovery of the said Schedule D land. In addition to that, the plaintiff, the defendant, the counterclaimant, the defendant oblique the counterclaimant had also sought for partition of the Schedule A land on equal basis and other reliefs. The trial court, during the pendency of the injunction proceedings, instituted the proceedings under Order 39, Rule 7, and sought for a report upon inspection. An inspection report was submitted to that effect that the setbacks maintained by the defendant on the north and the east side was in accordance with the permission. However, on the west and the south side, it was less than what was required as per the permissible setbacks as per the building bylaws. But the fact, however, remains, taking into account the dispute involved herein, that if there is a mention on the basis of the inspection that there was some amount of setback which was there, maintained, some setback have been maintained, it would mean that it would be an implied aspect. It could be impliedly understood that the construction was done within the land of the by the defendant. The learned trial court, by an order dated 21/8/2023, disposed of the injunction application. Thereby restraining the defendant number 1 and 2 from occupying the suit land, which would be the Schedule C land, and undertaking any construction over the suit land till the disposal of the suit. In addition to that, the defendant numbers 1 and 2 were also restrained from causing any damage, alteration, and transfer of the suit land in any form and manner until disposal of the suit or until further orders. Being aggrieved, an appeal was preferred by the defendant numbers 1 and 2 before the court of the District Judge Gwalpara, which was registered as Miss Appeal number 6/2023. The said appeal was endorsed to the court of the Additional District Judge Gwalpara for disposal. The learned First Appellate Court allowed the said appeal by setting aside the judgment, the order passed by the learned trial court, dated 21/8/2023. And it is under such circumstances the instant proceedings have been initiated. This court have heard Mr. B.D. Dekar, the learned counsel, appearing on behalf of the petitioner. Initiated. Full stop. Absolutely. It is also very pertinent herein to mention that pursuant to the filing of the instant petition, an application was filed which was registered and numbered as IAC 1109/2024. Seeking an injunction, thereby restraining the defendant numbers 1 and 2, their men, agents assigned from carrying out construction over the suit land, that is Schedule C land, and or changing altering the nature and character of the suit land, that is Schedule C land, and or creating any third party interest over the same. This court, by an order dated 10/4/2024, directed that status quo be maintained in respect to the suit property. In addition to that, there was also a direction that no construction work shall be undertaken in respect to the suit property till the returnable date. Let this court therefore consider, in the backdrop of the above, let this court therefore consider as to whether the learned First Appellate Court had exercised its jurisdiction beyond the confines, beyond the powers conferred upon it in passing the impugned order, thereby setting aside the injunction order passed by the learned trial court. From a perusal, the learned first appellate court, while deciding the said appeal, observed that the plaintiff did not have a prima facie case insofar as the suitland was concerned for grant of an injunction, taking into account that the Schedule C land was not described in the manner in which it ought to have been. Taking into account that for the purpose of grant of an injunction, the three golden principles has to coexist. The learned first appellate court interfered with the injunction order on the ground that there was no prima facie case for grant of an injunction for going for trial. In the previous segments of the instant judgment, this court had duly taken note of that an admission had come into light from the part of the plaintiff that there was a boundary wall on the north of the plaintiff's land. It is not clear from the plaint as to whether the boundary wall exists within the plaintiff's, it is not clear from the plaint as to whether the suit land exists beyond on the north of the boundary wall. It is not understood as to why the plaintiff did not expressly state that his boundary, more particularly towards the north, was bounded by a boundary wall. In the opinion of this court, the learned first appellate court was therefore justified in arriving at the finding that the plaintiff did not have a prima facie case for going for trial insofar as for grant of injunction. In respect to the suit land, on account of the vagueness or lack of clarity in the description of the suit land. Now coming to the question of balance of convenience. Although the learned first appellate court did not go into the said aspect of the matter, but this court, taking into account that there is an injunction application filed, would also like to deal with the said aspect. From a perusal of the various photographs which have been placed before this court, it transpires that the building in question have already been constructed which is on the northern side of the plaintiff's land. The brick walls have been also the walls have also been constructed It is also seen that there is no mandatory injunction sought for. In respect to the construction of, in respect to demolishing or recovery, or for the purpose recovery of possession of so far of the land, the demolition of the building, or for the matter for demolition of the building, recovery of possession, for demolishing of the street building. Under such circumstances, in the opinion of this court, the balance of convenience would be in not stalling the further construction. The third aspect relates to irreparable loss, harm, and injury. Where did they mention they are going to break it?
96.
Page
96
of
of the CRP.
Huh?
CRP of CRP. Of the written objection file against
Page
the
96 of the CRP.
no, no. Page of the IA. No, I mean written objection. This is the written objection against the miss case, and the relevant portion is page 90.
now in the before the court also have they done it?
Yes, this is it's the part of the record, written objection by the OP. It starts annexure
No,
6.
here. In before this high court, have you done it?
Here, no.
No.
For the high court. There are.
In respect to this, in respect to the said principle, this court finds it very pertinent to take note of the submission made by Mr. K.N. Chaudhary, the learned senior counsel, wherein he duly submits by drawing the attention of this court to paragraph number 23 of the written objection filed by the defendants before the trial court. Wherein it has been categorically mentioned that the defendants undertake on oath to demolish the RCC building being constructed if at the end of the trial the same is at all found to have encroached either into any part of the 8 feet common road or into any part of the petitioner's land. The learned senior counsel submits on instructions that the petitioner, the defendant number 1 and 2 also continues to give the same undertaking before this court. Under such circumstances, this court would therefore construe the same as an undertaking being given before this court. The learned counsel for the petitioner submitted that after making inquiries, it has been come to light that the petitioners are not only are not constructing a residential building, but
Respondent is under. It has come as petitioner.
that the defendant numbers 1 and 2 are not constructing a residential building, but it is a commercial
Come
residential building. And as such, there is every likelihood of creation of third-party rights. Mr. King Chaudhary, the learned counsel, the learned counsel for the petitioner therefore submitted that if any alienation of the suit property of the building so constructed by the petitioner, by the defendants, is not restrained, it would be difficult on the part of the plaintiff at a later stage, plaintiff of the petitioner at a later at the end of the trial, to execute the decree in view of the creation of third-party rights. Mr. Kane Chaudhary, the learned senior counsel, appearing on behalf of the learned senior counsel, appearing on behalf of the defendant numbers 1 and 2, duly submits on instructions that as on date there has been no alienation to or creation of third-party rights. He further submits that any third-party rights, if created, would be subject to the final result of the instance of the suit. This court takes the submission made by the senior counsel as an undertaking also before this court. This court also further takes note of that the construction have already begun and is at the advanced stage. Stalling the construction during the entire trial would not, that too, an entire trial, would not be in the interest of justice, inasmuch as the loss which would be suffered by the defendant numbers 1 and 2 would far exceed, taking into account that construction materials and all other expenses, taking into account construction materials, etc., would be damaged if they are just kept, taking into account that the construction materials which are already lying would become unusable. In addition to that, if at the end of the trial, the plaintiff suit is dismissed, the defendants, number 1 and 2, cannot be compensated by any decree of the court. Under such circumstances, this court is of the opinion that the plaintiff here, the plaintiff oblique the petitioners, do not have the opinion that there is no irreparable loss, harm, and injury for the purpose of stopping the construction which is already at the advanced stage. This court, however, makes it clear that the said observations that makes it clear that the construction that however makes it clear that this court have not granted the injunction solely by taking into due considerations the undertaking so given, which have been recorded herein above, and the same shall be duly considered by the learned trial court at the end of the trial, while passing the judge, while disposing of the suit. Before concluding, this court further finds it relevant to deal with the submission made by Mr. B.D. Dekar, the learned counsel for the petitioner, that the constructions so carried out as per the inspection report is in violation to the building permission. This court, taking into account that there has been no relief sought for in the plaint against the Goalpara Municipal Board, who had granted the construction permission, is not inclined to accept the said submission. Be that as it may, the petitioner herein would be at liberty to take the said matter before the said authority, and the pendency of the instant proceedings or the suit shall not be a bar. Taking into account the above, this court therefore is not inclined to interfere with the order passed by the learned First Appellate Court, dated 27/3/2024, passed in Miss Appeal number 6/2023. Interim orders passed, if any, passed in IA C1109/2024 stands vacated. No more long judgments today. Short order. One matter is over. Let me come back. Yes, which order you are challenging?
My lord, I am challenging, my lord, order dated 9/7/2019.
What?
Annexure P3, page 31 and 32. Page 31, my lord.
And
And my lord. Annexure P8, page 41, my lord.
And
My lord, these two orders.
why have you woken up after 2 years?
My lord. Since my lord,
One is 5 years and another is 2 years. Why?
lord, there is a delay, my lord, petitioner, I have explained in the,
No, why?
my lord, first of all, my lord, Corona period is over, there are.
Forget about Corona period.
Thereafter, my lord, petitioner.
Corona is not there from 2022. We are in 2024. Why?
Petitioner, my lord, there is some financial problem also there is.
So you can challenge at any point of time.
That is, I have explained, my lord, in paragraph last.
What do you want? Dismiss?
Kindly consider these are, my lord,
Absolutely no.
paragraph 21, my lord.
This order to 9/7/2019, the question doesn't arise. As regards the other order, you can make a submission that you want to withdraw this petition and file an application seeking leave. I can say that if he files such application, the court shall consider. This is an application filed under Article 2 to 7 of the Constitution challenging the order dated 9/7/2019 as well as the order dated 3/3/2022. There is no explanation in the learned counsel appearing on behalf of the petitioner submits that the trial court did not consider that there is still a scope left. They did not consider the provision of Order 8, Rule 1A bracket 3. 1A bracket 1A bracket 1A2 bracket 3 of the code, which still affords an opportunity to the defendant to crave leave, to seek the leave of the court to produce any document. He, however, submits that the defendants, out of not being properly advised, did not file such application. He therefore submits that he may be permitted to withdraw the instant petition and file an application seeking the leave in terms with the said provision. Taking into account the above, the instant petition stands dismissed on withdrawal. However, the petitioner would be at liberty, petitioners who are the defendants in the suit would be at liberty to file an application seeking leave. Provided the evidence of the defendants is not over yet.
Not a, when next date is fixed for, my lord, list of witnesses by the, to be submitted by the plaintiff, my lord.
In 2022, that is there, and in 2024, we are now into the stage of list of witness.
My lord, I have stated in paragraph,
Where's your last order? No, that remains, provided the evidence of the defendants is not over.
paragraph
Pusto.
23.
The learned trial court shall, upon such application being filed, shall duly consider the same in accordance with law.
Number 4 for admission.
May I please, your lordship? This is filed by the petitioner lordship in order dated 20
What are you challenging?
at page lordship, page 61. That lordship, during the pendency of this revision petition lordship, opposite party number 1 expired. We have filed delay condonation petition lordship and for setting aside the abatement proceeding lordship. We have unable to file it within 90 days.
Huh?
We are unable to substitute opposite party, the successor of the opposite party number 1 within 90 days. There is a delay of 28 days. That is in IA number like 506.
Which order you are challenging?
Order lordship, challenging lordship, annexer lordship, page 61 lordship,
61.
page 61.
What is that order?
Otherwise, Lordship, the petitioner was not allowed to adduce evidence. Issues were same, Lordship.
Yes. What is wrong with the order?
Kindly.
Yes, Mr. Kusami. You are there? Yes. I don't want to dismiss it in his hands. Tell me. What is wrong with the order?
No, nothing is wrong, but the only thing, my lord, there was communication gap. Absolutely, my lord. The
If the plaintiff is not interested.
plaintiff is very much interested.
No, he can't be interested if there cannot be a communication.
Unless, my lord, he gets intimation of what is to be done, what is the next.
What is to be done means he has to be in contact. When the case is being fixed for evidence, 4 years have passed by. Why should this court at all interfere?
But, my lord, we have filed an affidavit, my lord, whereby we enclose the complaint that he had filed, my lord, the plaintiff had filed before the bar council against the my lord, but unfortunate, my lord, that this council has also in the meantime expired. And the instruction is that bar council has also closed the proceeding.
Hmm?
The,
You mean to say the complaint nothing has happened?
this complaint, my lord, the advocate concern expired, my lord, in the meantime. So they closed it.
The advocate expired. You are appealing for whom, Mr. Mukit?
I'm for the defendant counterclaim. Defendant number 1 counter. Is expired this first.
It expired.
Expired, my lord. And then we have filed, I think, Wakaranama, we have filed for LA.
Hmm?
File substitution application. It was later, so therefore later we filed application amendment. Case amendment, my lord, and so they had appeared for the wife of that defendant. This was
IAS in it.
506.
এইখন দিয়ক নালাগিব নি গোটেই এইখন হ'ব How did you know that he'd expired? Who informed you?
No, actually, my lord, if I remember, we went looking. There's a shop, my lord. The garage was closed down. Then we made inquiries in the gearbox, my lord, that area, my lord, locality. Then we came to know. Para 2 onwards, my lord, of my application under section 5.
এই তিনিখন application. The three applications being IA number one, IA number 506/2020. IA number 511/2020. And IA number 513/2020 are applications for condonation of delay of 28 days, comma, setting aside the abatement insofar as the respond number one, the proprietor of the respond number one is concerned, as well as for substitution of the legal representative of the proprietor of the respondent number one. Full stop. This court have duly taken note of that the proprietor of the respondent number one expired on 9/2/2018. However, it was not within the notice of the applicant, which the applicant came to learn only in the fourth week of March 2018. Thereupon, after making necessary inquiries, only on 22/6/2018, the applicant could come to learn about who are the legal representatives of the proprietor of the respondent number one. And in that process, a delay of 28 days have occurred in filing the application for setting aside the abatement. This court is of the opinion that the cause which have been stated in the application constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act, and accordingly condones the delay. The application being IA number 511/2020 is an application for substitution of the legal representatives of the proprietor of the respondent, is an application for setting aside the abatement of the proprietor of the respondent number one. The reason being sufficient in the opinion of this court, the abatement is required to be set aside. Abatement insofar as the proprietor of the respondent number one is required to be set aside. Accordingly, this interlocutory application IA C number 511/2011 is allowed. As regards the application number IAC 513/2018, it is seen that the proprietor of the respondent number one, Tinku Sarkar, upon having expired, he has left behind Srimati Supriya Sarkar, his wife.
The daughter is also there. My lord,
What is the name?
name, my lord, not disclosed here. I will have to find.
You
out.
know
I don't know the name. My lord.
whatever the name, not necessary. The firm is a proprietorship firm.
Firm doesn't remain, my lord. It was a proprietor firm. That thing has closed. That establishment has closed. Wife is there. My lord.
One of the legal representative is there. It's okay. Accordingly, this court substitutes the wife of the deceased proprietor of the respondent number one firm. whose name duly appears in the paragraph number in the course title of the instant application. As opposite party number 1. On the basis of the above, the IA number 1513/2020 stands allowed. The counsel for the applicant is directed to file a fresh memo of parties before the registry of this court by 5/6/2024. And on the basis of the same, necessary corrections may be made before the race in the records of the accompanying revision application, and the same be updated in the CIS. This is the matter again on 10th of June 2024.
Can we get 2 or 3 more days, my lord, instead of 5, 6, my lord?
Why?
But before 10/6, well, it will be listed on 10/6. Before that, we'll.
Why? You can do it just now. It is for you. They don't need to file. You have to only file a memo of parties who are the name of the. Is it now so difficult?
My lord, I am appearing for the respondent number 2. I have not received copy of the revision petition. Revision petition copy is not received.
We had taken, but we can. Oh, that, there was an earlier council, my lord, it was different, my lord. He was,
Your
For the first time I
petitioner,
appeared for this statement.
I hope Mr. B.D.
I'm-
Goswami, later on, that very petitioner does not blame you.
what's obliged, my lord?
Give your name, Mr. Counsel. We'll put it,
A Parvez.
give it
It is
out
in
there.
the course list.
No, write it out there, which is being used. What is this? 5, Miss A. Bora. Where is she?
This CRPIO was filed for seeking adequate time to file a written statement.
Ah.
And we have given sufficient reason explaining paragraph 7 of the petition.
Hmm.
And on the last.
How
day
much
we do-
time?
On the
You are
last day-
referring to page 59?
paragraph 7 of the petition lordship. To explain our reasons. And the case is fixed on 6/6/2024.
Did you file the written statement?
So we are about to file, but on that very date, it was a 90 days period was over. So the court did not allow us to file the written statement.
Then,
Then some
did you
miscellaneous.
file the written statement thereafter? Did you file the written statement thereafter?
We are about to file, but we are not allowed. The written statement is already ready and
So next date is on 6/6. You're going to file the written statement on that date?
yes, sir.
Allow it. This is an application challenging the order dated 29/9/2023, passed in title suit D 91/2022, whereby the learned trial court, on account of completion of the period of, on account of not filing the written statement within 90 days, have debarred the petitioner, who is the defendant in the said proceedings, from filing the written statement. Pustak. Miss A. Bora, the learned counsel appearing on behalf of the petitioner, submits that on account of difficulties beyond the control of the petitioner, the written statement could not be submitted. Within the due period. She, however, submits that the written statement is ready and can be filed on any day as may be fixed by this court. She further submits that these are matrimonial matters, and as such, it is before whom? District Judge Bongaigaon. She further submits that these are matrimonial matters. This is the present matter. A suit is a matrimonial suit for divorce. And the petitioner herein would be severely prejudiced if the written statement is not permitted to be filed. Taking into account the above, this court is of the opinion that as the written statement is already ready and the learned counsel further submitted that the counsel for both the sides has submitted that the next date is fixed on 6/6/2024 before the court of the learned District Judge Bongaigaon. A further opportunity should be given for the interest of justice for filing the written statement. Accordingly, this court interferes with the order dated 29/9/2023 and permits the petitioner herein, who is the defendant in title suit D number 91 of the 2022, to file the written statement on or before 6/6/2024 before the court of the District Judge Bongaigaon. It is made clear that if the written statement is not filed on that date, the court shall proceed with the suit in accordance with law. Full stop. This court further, there's no stay, na?
Oh, Lordship, no stay.
What is the status report?
On the earlier date,
Hearing on petition, no?
Right, Lordship.
My lord, the appellant is the absolute owner of a plot of land measuring 8 feet as lot. Earlier, that land was a annual patta land in the name of the appellant lordship. And thereafter, he applied for conversion of the annual patta to Khira's periodic patta lordship. Accordingly, the Khira's periodic patta was issued in the name of the present appellant lordship. Lordship may come to page
Mr. Roy, what has happened on 18/4?
for lordship. It is mentioned, lordship, page 5, paragraph.
But
That on 18/4/24, this honorable court was passed an order, trial court passed an order, typographical error, that the service report of the summons to the defendant is returned without service if concerned person is not traceable in the given address, and the plaintiff was directed to take fresh steps fixing 22/5/24 SRN summons. Then lordship in the next date, 22 lordship, para 6. On 22nd 5/24, the appellant plaintiff filed a moved a petition in TS number.
where is the order of 18/4?
18/4 lordship order is petition lordship I have annexed, order I have not.
What you have enclosed?
Petition I have annexed for correction of the address of the defendant. So
Then what happened?
that was allowed.
And then on 22/5, what happened?
22-5 Lordship, we take the step. Chota sir. On on Lordship, on 18, this is the 20-5 Lordship, I am having the order sheet. I was allowed to take steps on the change address of the defendant. Accordingly, I took the steps.
Then what happened? Nothing has happened to you now.
No, Lordship, when I filed this suit, I have filed an ad interim injunction petition. In that case, Lordship,
It is against the notice.
against the notice. But Lordship, without discussing the three golden principles, Lordship, the
Huh?
injunction has been, that issuance of notice amounts to refusal of the injunction, Lordship.
Understood.
Ah.
Not refusal, not to grant an injunction without hearing the other side.
Against which also appeal is maintainable as per the full bench.
Is it a mandatory that that injunction should be given? That has to be something shown.
Is to consider
Huh?
the impugnment. I am the absolute honor, Lordship. The circle officer mutated the name of the defendant with. my
Now,
name.
are you in possession?
Yes, we are in
If you are in possession, then what is to fear?
protected, no, my lord. Your Lordship is fully.
Now,
aware
what
regarding-
happened in the meantime till date? What is the situation? Let's
This
see
is
your
because
eye.
The defendant is trying to occupy the Suitland B, C, D forcibly. and illegally. He has no right title interest. I am the sole pattadar, Lordship. Lordship, will you please see the title documents which I had annexed along with the pledge. First of all, page 25, my lord. This is the Jamabandi, which stands in the name of the present appellant Lordship. And he had sold land to one Jadhav Kumar Neva. His name is also muted. Nowhere the name of the respondent is Lordship Shankar Pradhan. Nowhere his name is mutated. And on this page 25, Lordship, there is an order that the Mayadi Patta was converted to KP Patta, Lordship. In the remarks column of the Garuda.
In
Yes.
whose name?
Lordship.
In whose name?
Appellant name, Mon Bahadur. Page 25, order of the revenue circle dated, this is the revenue case number, this is that land measuring 8 bighas of Patta.
And what is the next day? 10/7. Okay, we do one thing. We issue a short notice making it returnable on 24/6.
Till
get-
take position in respect of this.
Status quo I'll direct to be maintained till then, provided you serve it.
Okay.
And it's an injunction order, so obviously you have to serve it.
Today I'll take it.
Appeal to the, appeal, issue notice. Call for the issue notice returnable on 24/6/2024. Steps be taken by way of registered as well as usual. In addition to that, the petitioner is also, appellant is also directed to take effect service upon the respondent number, sole respondent by way of registered as, by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. It appealer hold, huh? Next. Interlocutory application on I. Issue notice making it returnable on 24/6/2024. Steps be taken by way of registered as well as usual upon the respondent by during the course of the day. I got to during the course of the day. In addition to that, the petitioner is also the applicant is also directed to take steps by way of registered by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The instant appeal, the accompanying appeal has been filed, being agreed by agreed by the act, by the order dated 18/3/2024, whereby the learned trial court did not grant an ex parte ad interim injunction. Full stop. It has also been brought to the notice of this court that the next date is fixed before the learned trial court on 10/7/2024. The present application is an application under Order 39, Rule 1 and 2, read with Section 151 for passing an ad interim temporary injunction restraining the respondent herein from disturbing the peaceful possession of the petitioner over the Schedule B, C, and D premises in any manner. Full stop. The learned counsel appearing on behalf of the petitioner drawing the attention of this court to various documents as well as the copy of the plaint has submitted that the plaintiff herein, the plaintiff oblique the applicant herein is the owner of the plots of land
Para 20 is relevant law, page 7.
types submits that drawing the attention of the plaintiff as well as the documents enclosed therewith submits that the applicant oblique the petitioner is the petitioner oblique the plaintiff is the owner, was originally the owner of the Schedule A land. However, after effecting various sales, however, after selling 4 bighas, 2 katha, 10 lechas of land, the petitioner oblique the plaintiff oblique the petitioner still remained the owner of 3 bighas, 2 katha, 10 lechas of land which have been specifically described in Schedule B, C, and D. He further submitted that the opposite party herein is the. You don't know the address of your elder brother?
Lordship, he has having 2 houses, one at Pipazar and one at Beltola, Guwahati, Lordship. So when the suit was issued, he was there at Pipazar, but thereafter since then he is residing at Beltola, Guwahati. So that's why address was changed.
Submits that opposite party herein, however, has got mutated. The Schedule B, C, and D land in his favor. And on the basis thereof, have by an order dated 17/3/2022. And on the basis thereof, the opposite party have been trying to dispossess the plaintiff oblique the petitioner. It was further mentioned in the instant application that on 7/1/2024, the opposite party came to the Schedule B, C, D land and tried to occupy the said land. However, the opposite party could not do so. He further submits on by drawing the attention to paragraph number 24 of the instant application that on 9/3/2024 and 25/2024, the opposite parties, along with his associates, had come again to the Schedule B, C, and D land and tried to dispossess the plaintiff oblique the petitioner. However, could not. He therefore submits that there is a serious threat to the possession of the plaintiff petitioner. And as such, an ex parte ad interim injunction be granted. He submits that if the injunction is not granted, the accompanying appeal would become infructuous and irretrievable injury would be caused to the plaintiff petitioner. Taking into account the above, this court is of the opinion that taking into account the above, and also upon perusal of the materials, including the instant application, which is supported by an affidavit, this court is of the opinion that the plaintiff have been able to portray a prima facie case for going for trial. And according, as regards the balance of convenience, if the plaintiff is in possession of the suit property, then such possession of the plaintiff cannot be disturbed with sense in accordance with law. It is also very pertinent to note that if the plaintiff is in possession of the suit property, more particularly described in Schedule B, C, and D, then any dispossession would not only create complications, but it would also have the effect of causing irreparable injury to the plaintiff. This court, however, is also aware of the fact that the plaintiff has sought for this order ex parte, and the other side had not yet been heard. It is also not known as to whether the other side is in possession of the suit property, more particularly described in Schedule B, C, and D. Taking into account the above, this court is of the opinion that till the next date, the parties are therefore required to be directed for maintaining the status quo as regards possession in respect to the Schedules B, C, and D premises as described in the plaint. Accordingly, this court therefore directs both the plaintiff as well as the defendant, plaintiff oblique petitioner oblique the opposite party, and defendant oblique opposite party, to maintain status quo as regards possession over the schedule B, C, and D premises. Till the next date. That is 24/6/2024.
Problem.
Yes, Mr. Shom,
Yeah, appellate.
you have a case or not?
Case is there, Your Lordship. I have a case.
If you have a case, then why did you take an adjournment earlier?
No,
There has been a good reason for that.
last occasion I did not prepare on this, Your Lordship.
Tell me, if you don't have a case, don't spoil my time today.
Lordship, I was the plaintiff, Lordship.
You have a good case, may have a very easy case next week and then next week. But if you don't have a good case, argue.
I may be given, Lordship.
At the request of the learned counsel for the petitioner, matter will be listed on 10th of June.
How like Your Lordship?
It.
Agree the lordships.
Yes. Again, Mr. Ormuya,
Lordships, second appeal. Second
understood.
appeal,
You have a case or not?
a good case, a law point involved lordships.
Fantastic. Because you took adjournment on the last occasion.
Last occasion because paucity of time, lordships,
Yeah,
that's
chalo.
why I have taken.
Tell me, what is your point?
My lord, I am the plaintiff appellant.
Where is
I-
your substantial questions of law?
Question law, lordship, 1 and 2. Other higher court from
Whether the judgment and degree of both are legally sustainable when the defendant obtained divorce from her father and when she was in. Whether the finding and. These are not there. Whether the judgment and degree. Presence of clear denial by the plaintiff. Okay,
My lord,
what is your case now?
My case is, I filed a suit for declaration that a marriage between the plaintiff and the defendant number 1 is illegal, void, inoperative. So
Declaring that a marriage between plaintiff and the defendant number 1 legal, void, inoperative. Title 2 as
Why?
is.
prior to that, the number 1 married the defendant.
That the marriage between the defendant number 1 is subsisting. Subsisting. And the defendant 1 continues to be the legally married wife of defendant number 2. Then what happened?
Here is the due to subsistence of earlier marriage between the number 1 and 2.
What is the
Marriage
stand
to
of the defendant number 1?
defendant-
You are paying for defendant number 1?
my lord.
Yes, what is the stand of the defendant number 1?
She stated. When number 1 stated that she was newly divorced by the
Earlier husband.
earlier.
So therefore your basic case is that there could not have been a legal marriage between you and the defendant number 1 without the defendant number 1 having divorced the defendant number 2.
Yes.
That's your case.
That is the case.
Entire case. Okay. Now what happens? Now how does the
Just
trial court
kindly
look
see.
into it? Title suit. Whether the suit is maintainable, whether the marriage between defendant
Number three,
whether
yes.
the plaintiff is entitled to the degree as framed. What is issue number 3?
My lord, vital point is page 27.
Is is what I'm also looking at. Vital point involved in the suit is that empty was being himself and becoming involved in at the marriage. What is this cabin number?
Kabindama lordships, that is.
Marriage
agreement
marriage
of
certificate, my lord.
Certificate, marriage certificate,
Marriage
that
between
here
the
is the
different-
case lordship. Talaknama and Muktinama. All have been paused.
Issue number 3. How does the appellate court decide?
My lord, relevant part is page 44, man. Same vital question. Laboratory. Paragraph 27, page 24, 44, man.
Then,
That is the exhibit 3, petitioner, that Mukti. First, kindly see page 14, Lordship.
My lord,
before-
may I be allowed 1 minute, my lord?
Page 14.
Page?
Page 14, 1 for WS of the defendant.
48.
14. Top line, Lordship, right side. The fact is that. Okay.
Yes. Where?
The fact is that defendant number 1 was duly divorced by the defendant number 2, and by accepting the divorce, the defendant number 1 executed a deed of release, Muktinama, in favor of the defendant number 2. And after about 3 years of divorce of the unsigned defendant, the plaintiff married the unsigned defendant number 1. Here is the case, Lordship, that Muktinama was issued prior to that, and divorce was issued after 1 year. That to exhibit, Lordship.
No. Whatever may be. Did they exhibit the Muktinama?
Exhibit 2 is the Muktinama. Exhibit B is the Talaknama.
Muktinama is not there.
Muktinama is not there, but it was stated in the evidence as well as
What is
in the
this?
Muktinama, the deed of release, Lordship.
Was this exhibited?
It was not exhibited, but there is an evidence. Lordship, exhibit B was there. Date is very
As to
important.
whether this document was exhibited or not.
It was that statement even in the evidence as well. It was not exhibited by a defendant. But here is the case, my lord, under section
You should have called for.
256. Lordship, 256. 256 is that when plurality of husband, there is no marriage, marriage at all. Exhibit 3, even he stated, the defendant stated that her husband was insane. And that time,
Exhibit 3 did not say, as per the first appellate court's reading of the evidence, it was mentioned that she said in Exhibit 3 that after he was mentally not well, but later on, after recovering, he gave the talak. That is the finding of the first appellate court on Exhibit 3.
And in the second marriage, Kabinnama, it is clearly mentioned she is a divorcee.
wait,
It is admitted position.
my submission is that for a moment, still he was insane. For a moment, it was what is that? For a moment, it was not duly considered, because for a moment she was maybe well, Lordship, recovered. On that time cannot be. Lordship, kindly say Muhammad Allah to section 256 and 308. And that Muktinama is also, Lordship, 1 year before. It has to
Muktinama
be
is
after
not there
1
on
year.
the
The evidence also stated, Lordship, by
Muktinama is not there on the section.
but section 256, Lordship,
Yes.
plurality of husband is not lawful for a Mohammedan woman to have more than one husband at the same time. A marriage with a woman who has a husband alive and who has not been divorced by him. And then section 308, Lordship, divorced by talaq. Any Mohammedan of sound mind who has attained puberty may divorce his wife whenever he desires without assigning any cause. Here is that he was insane, Lordship. At that time,
It is a finding of fact right there that he is not insane.
and that talaknama is false, Lordship. Kindly see the,
Did you
The
challenge the
evidence-
talaknama? No. Did you challenge the talaknama?
yes, I raise objection against.
No.
talaknama.
Did you challenge the talaknama?
I have not challenged.
It's forced.
Lordship,
I
one
told you,
evidence-
I gave you an opportunity. Now the bad luck is so now I have to dismiss.
Sir, may I be allowed only 1 minute, something very important. My lord?
When I am dismissing, what is there important out there?
My lord.
Take your
one
sit down.
evidence,
Yes.
in the evidence, Lordship, and Muktinama, she stated she
It is a question of fact.
obtained
Finally arrived at on a reading of Exhibit 3. Your entire case is Exhibit 3.
exhibit 3, Lordship.
And Exhibit 3, the finding arrive at unless you say, yes, the Exhibit 3, there is a perversity. Can you say that? No, are you, can you say that, this finding at page
Lordship.
46, paragraph 34 is perverse.
Appellate court.
Page 46, paragraph 34 is perverse.
That is, plaintiff side argued the exhibit is the deposition defense number one,
Para 40, page 46, para 34.
44. 34. I have produced the exhibit 3 and it transpired that defense number 1 in a deposition by the exhibit stated that after recovery from mental illness, defense number 2 pronounced talaq on her. Moreover, neither defense number
So this is a finding of fact. Can you say this to be perverse? Because your entire case is exhibit 3.
exhibit 3 lordship, but here
No more.
exhibit 1 important lordship aspect, she specifically
Your
said that there
substantial
is an-
questions of law looks fantastic from outside, but
lordship,
you will
she
never know.
specific
From
exhibit
inside, it
also
is
same
absolutely
time
hollow.
exhibit B and Muktinama lordship. Exhibit B is the Talaknama lordship.
I am not going to go into a document which is not there on record.
Lordship, in the evidence lordship, that has to be considered, but
That is not a document which is on record. The only case is exhibit 3.
That's
Exhibit
why
3, it
exhibit-
is no perversity reading. Matter ends.
perversity because of Muktinama lordship.
Muktinama, why didn't you use that, ask them to produce that document during the trial? They have mentioned this particular aspect. You could have very well asked to produce that document. Once it is being produced, then it becomes a piece of evidence. Why didn't you do that?
That very
In fact, they didn't
Yeah,
get the
Muktinama
well
and-
advised of Mr. F.U. Borgoya. What
lordship.
to do? Dismiss. Dismiss is with cost. Withdrawal is free. which-
Sometime maybe.
My lord, by this
Uh,
case.
no time. I told you beforehand. Ask for time. I asked you, please take time. You said, no, I have a good case.
My lord, taking plea of this pendency of this case, my lord, he is denying the maintenance of the child and the wife for long and long and long.
That will not fall under this case.
Only
That's-
it is
that's
filed
the
after
real
being,
case is that
maintenance
it
being
can be-
filed and he appearance
is-
and some contest being made, then it is filed.
So it is a fit case for dismissal today itself.
In both the court dismissed with cause, my lord.
The cost throughout too is there. Now remaining is today. 11,000. How much?
My lord, already I am suffered lordship. I am paying maintenance.
No, you have.
Yeah,
You are not paying maintenance,
No, no,
nothing.
paying that findings are there lordship. There judgment against me lordship. I am paying that case. Is pending also before this court. Already
Dismiss,
suffered. I
no,
pay.
cost is there. Cost is
Cost,
there. There is no
cost is there.
quarrel with that. Lekho,
Lordship, that when
The
I already
instance-
suffered. I am paying her lordship.
lekho,
But-
heard Mr. F.U. Borgoya, the learned counsel appearing on behalf of the appellant. Mr.
A.K. Talukdar, my lord.
A.K. Talukdar appearing on behalf of the respondent.
Respondent wife, my lord. Respondent wife,
Respondent is only one. Respondent number one.
yes, my lord.
Respondent number one. Full. This is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 27/6/2023, passed in title appeal number 13/2021, whereby the judgment and decree passed by the learned trial court dated 4/10/2021 in title suit number 147/2016 was affirmed by dismissing the appeal. This court has taken up the instant appeal at the stage of Order 41, Rule 11, to consider as to whether the questions of law so proposed are substantially involved in the instant appeal, so that the same can be formulated in terms with section 100(4) of the Code of Civil Procedure 1908, for short, the code. for appreciating the contentions of the parties, for appreciating the submissions made by the learned counsel appearing on behalf of the appellant, insofar as the questions of law so proposed. This court finds it pertinent to take note of the brief facts which led to the filing of the instant appeal. The appellant as a plaintiff had filed a suit seeking declaration of rights, had filed a suit against the respondent number 1 herein, against the respondents herein. It was the specific case of the plaintiff that the respondent number 1 was married to the respondent number 2. It was the specific case of the plaintiff that the defendant number 1 was married to the defendant number 2. And during the pendency of the said marriage, the defendant number 1 married the plaintiff, and in terms with section 256 of the Mohammedan law, the said marriage was void. It is under such circumstances the suit was filed taking declaration that the marriage between the plaintiff and the defendant number 1 was illegal and void and inoperative. And accordingly, the defendant number 1 was not entitled to any claim, any right against the plaintiff. Semicolon, a declaration that the marriage between the defendant number 1 and 2 is still subsisting, and the defendant number 1 continues to be the legally married wife of the defendant number 2, and for temporary and permanent injunction. It is seen from the records that the defendant number 1 had filed a written statement denying to the contents of the said plaint, and it was the specific case of the defendant that 4 years prior to the marriage of the defendant number 1 with the plaintiff, the defendant number 2 had divorced the plaintiff, defendant number 1, by execution of a talaknama. On the basis, at this stage, this court finds it very pertinent to take note of that the said talaknama, which have been executed by the defendant number 2, has not been put to challenge. On the basis of the pleadings between the parties, as many as 5 issues were framed. The issue number 3, which is very pertinent for the purpose of disposal, for the purpose of the instant proceedings, pertains to as to whether the marriage between the defendant number 1 and 2 was still subsisting. This issue has relevance, taking into account that in view of section 256 of the Mohammedan law, a Muslim woman during the existence of a marriage cannot remarry, and such remarriage would be void. Both sides adduced evidence. The learned trial court dismissed the suit filed by the plaintiff by the judgment and decree dated 4th of October 2021. In doing so, the learned first appellate court, the learned trial court came to a categorical finding in the issue number 3 that the plaintiff had failed to prove that there was a divorce between the defendant number 1 and defendant number 2. There was no divorce between the defendant number 1 and defendant number 2. Being aggrieved, an appeal was preferred which was registered and numbered as title appeal number 13/2021 before the court of the civil judge Karimganj. The learned first appellate court by judgment and decree dated 27/6/2023 had dismissed the said appeal, and it is under such circumstances the present appeal has been filed. In that perspective, let this court now take into account the questions of law which have been proposed to be substantially involved in the instant appeal by the learned counsel appearing on behalf of the appellant. The first the question of law so proposed is as to whether the judgment and decree passed by, whether the learned courts below were whether the judgment and decree passed by the learned courts below were justified, were legally sustainable. When the defendant number 1 obtained divorce from her former husband when he was insane and subsequently got married with the plaintiff, which was contrary to the provisions of section 256 and 308 of the Mohammedan law. In the opinion of this court, this court had duly taken note of the judgments passed by both the trial court and the first appellate court. The only evidence on the basis of which the plaintiff claimed that there was a divorce between the plaintiff and the defendant number 1 and 2 did not happen was on the basis of Exhibit 3. This court finds it very pertinent to take note of that the learned first appellate court categorically held as regards the contents of Exhibit 3 in paragraph number 34 of its impugned judgment, holding inter alia that the deposition of the defendant number 1 in Exhibit 3 only stated that after recovery from mental illness, the defendant number 2 pronounced talaq on her. Under such circumstances, there being no perversity shown as regards the appreciation of the said evidence, more particularly Exhibit 3, the question of law so formulated is not a substantial question of law that can be formulated. The second substantial question of law, which have been also urged as substantially involved in the instant appeal, is as to whether the courts below have passed the decision ignoring and overlooking the evidence and documents placed on record and are for which the same is not perverse. The said question of law in the opinion of this court cannot be regarded as a substantial question of law inasmuch as the said question of law is vague, lacks material particulars, and lacks material particulars. It is pertinent to observe that to be a perversity, to claim perversity in respect to a finding, the question of law has to be specific as to what evidence was not looked into. Merely stating that certain evidence have not been looked into would not constitute a substantial question of law. The third substantial question of law, the question of law so proposed, is as to whether the courts below failed to frame any issue on the point of forgery of talaqnama in presence of the clear denial by the plaintiff in respect to the execution of the same. In the said question of law, in the opinion of this court, does not arise at all, inasmuch as the plaintiff did not challenge the talaqnama. Under such circumstances, the question of forgery or anything could not have been alleged. Under such circumstances, the said question of law cannot be also formulated as a substantive question of law. Accordingly, this court finds that the questions of law which have been proposed are not substantial questions of law which can be formulated, for which the instant appeal stands dismissed with cost quantified at rupees 11,000. In addition to that, the appellant herein would be the respondent here, number one herein shall also be entitled to cost throughout the proceedings. I stand dismissed.
First part, I kindly consider. Lord.
Huh?
First part,
No. I told you.
I am paying, already paying.
Okay, cost to go side taking into account that the instant appeal is being taken up at the stage of Order 41, Rule 11. This court is not inclined to impose any cost.
Obliged.
You see, you could have got an admission next week.
Control. Of the title also by way of adverse possession, and plea was also framed on that. And that was beyond the scope of the rent tribunal. Apparently,
Because the adverse possession question this court cannot decide. Then what do you do? Because your issue is that you have rights adverse possession.
yes. So in view of
The limitation only for filing of this suit.
limitation. Otherwise,
The
the
limitation
same
only,
issue may
no,
come
no,
up before other court.
no, whatever
Whether
may be,
reason
you
is-
will be entitled to the limitation
And
for
limitation
the
as well
period
as the
from,
certified copy matter.
now, you say,
Certified copy may be returned.
from 17/10/2023 till date will be excluded.
The certificate. Because there will be
That will be excluded.
the certified copy, my lord,
You will get it.
my lord.
My submission will be also. Though he is submitting, there's a plea for adverse position, but there is no counterclaim. There is no counterclaim from their side.
Not necessary. Adverse possession is normally a defense.
It is shield, not short. But recently Supreme Court has said,
But now it's also assured, but that is a different thing, but it is always a shield also.
and Lordship has asked earlier occasion that notice was issued or not. Notice was exhibited as Exhibit 7 for damage.
But anyway, he will withdraw this. Yeah. Or should I dismiss it on the ground of maintainability? I think I should
Dismiss it.
Maintain. Non-maintained.
Mr. This is an application under Article Section 115 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 19/8/2023 passed by the learned civil judge Kamrup, Amingaon in title appeal number 14/2019, whereby the judgment and decree passed by the learned trial court dated 25/3/2019 in title suit number 7/2009 was affirmed. From a perusal of the plain, it reveals that the said suit, that the suit so filed was a suit for ejectment of the place of the defendant on the basis that the defendant is a tenant occupying the suit premises on monthly rent. However, the petitioner herein, who was the defendant, took a plea that the plaintiff was not the landlord, having right, title, and interest upon the suit premises, and the defendant was not a tenant during the lifetime of late Madhav Das and did not become a tenant under the plaintiff. It was also the specific case of the defendant that he had acquired title upon the suit premises from 1st of April 1994 on the basis of adverse possession. That is what has been mentioned in his written statement.
Husband of the performer defendant allowed us to live there for a short period without any condition of paying rent, and accordingly from February 1994, defendant.
So therefore, when his stand is that to that effect, he may be a case of permissive occupier. If it is a case of permissive occupier also, it is outside the suit. First, outside the purview of a landlord tenant. It is also seen that the learned trial court decreed the suit in favor of the plaintiff. The learned trial court also taking into account the said stand which have been specifically taken by the defendant, thereby contesting the title of the plaintiff. The suit becomes a suit for based on title. In fact, a perusal of issue number 6A shows that the learned trial court had framed an issue as to whether the defendant occupied the suit premises against the will of the performer defendant since 1/4/1994 and acquired hostile title upon the suit premises after 12 years in 31st of March 2006. Be it as it may, the learned trial court came to a specific finding that the plaintiff defendant was a tenant and accordingly decreed the suit in favor of the plaintiff by the judgment and decree dated 25/3/2019. The defendant thereupon preferred an appeal before the court of the Civil Judge Senior Division, Kamrup at Amingaon, which was registered and numbered as title appeal number 14/2019. In the said appeal, also, the defendant categorically raised the issue of adverse possession and claimed hostile title as against the predecessor in interest of the plaintiff as well as the plaintiff, isn't it? Madhav Das's predecessor. Are you not claiming hostile title against him or not? That is what I'm asking you. The learned First Appellate Court, however, decided the issue number 6A against the plaintiff, against the defendant, holding inter alia that as the defendant was a tenant, the question of adverse possession did not arise. The issue number 6A was also again decided against the defendant. The learned trial First Appellate Court dismissed the said appeal by the judgment and decree dated 19/8/2023. It is against that the present application has been filed under section 115 of the code. Mr. P. Upadhyay, the learned counsel appearing on behalf of the appellant, petitioner, submitted that the plaintiff, the defendant, is not a tenant of the plaintiff, and the defendant claims rights over the suit premises on the basis of adverse possession. If the opinion, in the opinion and adverse, he further submitted that the learned First Appellate Court, trial court, as well as the First Appellate Court, did not decide the issue number 6A in the proper perspective, and as such, the judgments and decree passed by both the courts below ought to be interfered with. This court put a specific query upon the learned counsel appearing on behalf of the petitioner as to why the revision application has been filed invoking the jurisdiction under section 115 and not a second appeal. The learned counsel submitted that in view of the finding of fact arrived at, that the plaintiff, that the defendant is a tenant, coming within the ambit of the Assam Urban Area Rent Control Act 1972, and in view of the bar under section 8 of the said act, the revision application had been filed. Be that as it may, the learned counsel further submitted that the appellant, the petitioner, continues to agitate that the petitioner had acquired right over the suit premises on the basis of adverse possession. And as such, the suit which was filed was barred by limitation. When was the suit filed?
Suit filed in 2007, it was transferred to Rongya after the district court has been committed in Amingaon. And
Okay, take us. Taking into account the specific stand taken by the petitioner, in the opinion of this court, the said stand cannot be taken up in a proceedings under section 115 of the code, inasmuch as if the petitioner insists, inasmuch as if the question of title over the suit land, suit premises is the question, the same goes outside the purview of the Assam Urban Area Rent Control Act 1972. Considering the above, this court therefore holds that the instant proceedings under section 115 of the code is not maintainable inasmuch as there is a provision of filing an appeal against the said judgment and decree. There is inasmuch as an appeal is can be filed in terms with section 100 of the Code of Civil Procedure. This court duly holds that the petitioner herein have been bona fidely litigating before this court in the instant revision petition. Accordingly, this court further is of the opinion that the petitioner is entitled to the benefit under section 14 of the Limitation Act 1963. Accordingly, this court, though dismisses the instant petition on the ground of non-maintainability, however, liberty is given to the petitioner to file an appeal under section 100 of the code, subject to the same being permissible in terms with the provisions of the said, in terms with the mandate of section 100 of the code. This court further observes that the period from 17/10/2023 till date be excluded while computing the period of limitation. If in the circumstance the petitioner herein is advised to file an appeal. In addition to that, this court further observes and directs that in the circumstance, this court further grants the liberty to the counsel appearing on behalf of the petitioner to file an application before the registry of this court for obtaining the certified copy of the judgment and decree. Both the courts are here. Of both the courts the certified copy is only one only or two of certified copies. So of the judgment and decree passed by both the courts below. If such an application is being filed, the registry shall provide the certified copies so enclosed to the instant revision application within 5 days from such application. Within forthwith and not later than 5 days. With the above, the instant revision petition stands dismissed. Interlocutory orders, if any, stands vacated. Taking into account the order passed in the accompanying petition, the instant application has become infructuous. Serious in doing? Serious.
I was the defendant in the suit, Your Lordship.
Huh?
The appellant was the defendant.
Okay.
Case of the plaintiff was that the father of the plaintiff, Khanindra Burman, was the owner and possessor of 46 bighas of land.
You are the defendant. There is a substantial question of law.
That's from page 6, Your Lordship.
Page 6. Yes, tell me.
I was the defendant.
Hmm.
The case of the plaintiff was that the father, Khanindra Burman, was the owner and possessor of 46 odd bighas of land. And after his death, the mother, Rambeshwari, partitioned the suit land. There was a family
Who partition? Plaintiff is?
Plaintiff
Is Bharti Burman.
Plaintiff is Bharti Burman.
What is it?
He says that the father, after expiry of the father, the mother partitioned the entire plot of the father into 3 equal shares between the plaintiff, the defendant, and the pro forma defendant. Then the defendant sold all his portion that he acquired, and then the plaintiff had allowed the defendant number 1 to stay over a portion of land measuring 1 katha and 5 lesser from the year 2000. However, from 2017, he encroached a further portion of land measuring 3 katha and 15 lessers. So she filed the suit for evicting the defendant number 1 and his from that 3 katha and 15 lessers.
Where he has illegally disposed.
Allegedly illegally disposed.
Not the 1 katha.
Not the one.
Then
The stand of the defendant as well as the pro forma defendant also filed their WS, is that there was no family partition. And the basis on which they are claiming the family partition was the mutation of the land in favor of the plaintiff, Your Lordship. After the death of the father, the entire plot was mutated in the name of the mother, and then thereafter only the plaintiff, keeping aside the other legal heirs. So the stand in the WS was that mutation was illegal and unauthorized, and we will file a separate suit on proceeding against that.
have you done so?
That was noted. Situated thus, Your Lordship.
Mr. Mukherjee, if you don't have a case, take an adjournment. You have a case, do it. I'm giving you again another chance.
I will take 5 more minutes. Sir. As regards to the substantial question of law, as I have proposed as number 1, Your Lordship, the case was that there was an oral partition and we have encroached upon 3 kathas and some land. They have prayed for eviction, Your Lordship. There was no discussion, no issue as regards to whether there was an encroachment or not. even if we assume that the partition to be valid, which we are not submitting, Your Lordship, even if we assume the partition to be valid, there has to be a issue, and that has to be proved whether we have encroached upon their land or not. Issues Lordship will find at page 20 and 40, which are reflected in the judgment, Your Lordship. 40 part of that.
And
Issue number 4 and 5 were decided against me, which are vital to this matter. Whether the property of Faninder Burman has been partitioned. Even though we are challenging the finding, Your Lordship, even if we assume that it was partitioned, that does not show whether we have encroached upon their land or not. As per that is a substantial question of law that we are proposing. Then thereafter, substantial question of law number 2, Your Lordship.
wait. Now, where is the finding of the learned trial court that there was a partition and this suit land fell into her share?
There was no direct finding to that effect as well, Your Lordship. In fact, in page 22, Your Lordship, part of the appellate court's judgment.
What does it say?
Because the defendant failed to adduce any evidence. Their claim. That was entered in the Jamabandi in 1990. Assumption of correctness of the Jamabandi that basis.
No, Mr. Mukherjee, one thing is that how was this 3 big katha land? How much land was mutated in favor of the plaintiff?
Because the entire land in that Dagan Patta
Was done. Now, a mutation does not confer any title. But the fact that there is no challenge to the mutation also, all this while, after knowing also, such orders are to be respected.
There is a specific averment in the written statement as well that we were planning to file a counterclaim, but since the jurisdiction will exceed, we are not filing the counterclaim at this
That is your lookout. I'm not there. You have not filed, that is your lookout. But in view of that recent judgment in Rambala, court said that in a case, though revenue entries does not confer any title, but when revenue entries are, when authorities who have power cite the record of rights, which are akin to exercise of power similar to the civil court, because their record of rights is barred under 154. Then in that circumstances, these entries or orders which are being made by the revenue authorities affected and given effect to. And if now the land falls within that, and there is a prayer for recovery already there, whether framing of an issue has any material when the declaration has been duly given. You see, why Supreme Court or any other court have been all along holding that non-framing of the issue is not material if the parties knew about it. Here the party's specific case of the plaintiff was this. All parties went to the trial with that. Because framing of the issues is done by the court. And because of a court's fault, parties should not be prejudiced. Now, do you mean to say that the entire proceedings now, in view of the fault of the court to frame that issue, enough. Then Mr. F.U. Barbuya will say, look here, I also at the last moment requested, let me go get away. And I did not. I dismissed his appeal. So now the follow-up here also.
I could not formulate the substantial questions of law.
Because your formula is wrong. That is why. Why are you asking for the issue? I would have understood if the plaintiff did not claim. Here the entire suit land was the part of that land which is in her possession, in her mutation, a part of it. And it has been identified by a schedule. A decree has been given. She has duly asked for recovery of possession. The recovery of possession is a follow-up. May not be an issue has been framed or not. But once it is already decreed that yes, she is entitled to, the recovery of possession will follow. Isn't that the judgment in 2012 5 SCC? The Supreme Court categorically mentions that the recovery of possession will follow. Once a suit is based on, once the title is given, then the burden is on you. Read that. Very beautiful judgment. There is my, good night, Vito.
Lordship, there can be a substantial question of law.
There is
here.
no substantial question of law.
101 of evidence.
Substantial question of law is such that you are going to win that case. And therefore, I'll hear the other side. That is Vito to nine. Substantial question of law, Mr. Mukherjee, you have to understand. If I have to frame it, my coordinate bench cannot later on say that this is not a substantial question of law. He can only say, he or she can only say that this is not involved in the appeal in view of after hearing the respondent. So you have a substantial question of law. I don't know, many courts out there have taken this matter very easily. But if you have a substantial question of law, for this court, you have means you are going to win the case. Appreciate that. If you don't win the case, it cannot be on a prima facie. Prima facie question does not. Therefore, these matters of Order 41, Rule 11 has to be taken in that. Because why will it come? This is the second stage. People have already spent 15, 20 years down below. And now you are coming out here. One has to understand this is how. Recently, I delivered one judgment on that. When Mr. Mojumdar submitted to the effect that kindly don't decide the second substantial question of law because I did not challenge it. Then I've said it. Once a substantial question of law, unless it becomes insignificant or redundant, this court is bound to do in view of the legislative mandate in 105. So under such circumstances, and when I decide to that effect, I'll have to say that it is not involved. I can then also say that this is not a substantial question of law. Because if I say so, it would be reviewing an order passed by a coordinate bench. So you have to win the case if I have to do it. Not just for that it is an appeal is a sake of appeal. That is why the court have been very clear on this.
If I can formulate a better substantial question of law.
Better? You have no substantial question of law.
101 of the Evidence Act, if I may be permitted. With
What? 101? How?
Lordship, I will try to formulate.
How? Formulate now. No. No case of 101. He produced the revenue records. There's no quarrel with the fact that she is the daughter of the one. She claims that this is in the possession. She had her name recorded out there. You are not denying that she is not a coal. You have not filed a partition suit also. So, there is, therefore, you see that judgment of Ram Balak, which is a very relevant judgment of the Supreme Court, 2024, recently, May or April last or May. That was a case of the consolidation authorities. The Supreme Court said that revenue entries normally or in general parlance does not confer a title. Exact words, paragraph 16. But as these consolidated authorities or the revenue authorities exercise powers akin to the civil courts in respect to these matters, whatever orders are passed by these revenue authorities as well as so and so, unless they are challenged, have to be given effect to and are to be respected. Now you have not challenged. You can't help it.
Subsequent development, I'm not aware, but as of the file.
I'm not concerned. As of now, you have not, to my knowledge also. As you say so. And subsequent development is you have to do it by something. We are only out here on the basis of the materials. As of now, it is not done. So we dismiss it. This was, you spoiled so much of time.
Because your lordship, I have gone through
5,000 rupees on you as cost
97 and 96. Supreme
to the
Court.
Legal Services Authority. Do some service. Legal Services Authority, 5,000 on Mr. B.J. Mukherjee.
Next week, your lordship.
5,000. At the request of the learned counsel for the appellant, Mr. B.J. Mukherjee, the matter will be listed again on 7th of June 2024. Taking into account that the learned counsel submits that he would like to formulate the substantial questions of law in a better manner. List accordingly.
May it please, my lord.
Hmm.
My lord, the appeal was already admitted on 12/1/2000.
That is a different thing. You are on cross objection. Tell me, what is your substantial question of law?
My lord, my substantial question of law is that, my lord, my right title interest over Schedule B land was declared by the learned appellate court, my lord, but the recovery of possession was not given.
Whether the appellate court was legally correct in not deciding the suit for recovery of the Schedule B land in spite of declaring that the respondent had right title in interest of ER. Did you make the prayer?
I need to pray. That is my specific case, my lord. Right title interest in respect of Schedule B land and recovery of possession in respect of.
And that was not granted.
Right title was granted, but recovery of possession.
Why?
Because, my lord, the learned appellate court held that the suit land that is measuring 17 lessons, that was not partitioned. So I could not have claimed Schedule B land.
But you will be entitled to partition.
I agree on that. So that
Then,
is- that is why, my lord, my
sir, once you are given the right title
title
interest,
2005 Supreme Court comes.
no, whatever may be, you are given the right title interest in respect to a land which is, why the question of partition is required?
My lord, my case was that, my lord, initially there were 4 brothers who had 1 bigha odd lessons of land. After mutual partition, my father, that is one of the brother, he got 17 lessons of land. After his death, our brothers and sisters, that is amounting to 5 numbers of brothers and sisters, we got 3.5 lessons of land each. And according, Exhibit 3 is also there, my lord, family partition, settlement, it is there before the notary. So my claim was that I got 3.5 lessons of land, but my 2 brothers, that is the defendant number 1 and 2, they had constructed a building over it. Now I sought for that, since they are not giving me my share. Initially, they wanted to give me the share, but later on they refused that I have any right over the schedule land. So my claim was that right title interest in respect of Schedule B land should be given. And since, my lord, recovery of, since I have right title interest, so recovery of possession should also be given.
But is your share ascertained? Share is ascertained, 3.5 lessons.
3.5 lessons.
But is it identifiable?
It is identified. I have given the.
No, no. How is it identifiable on the basis of your proof? If they have constructed out there, how is it identifiable?
There is an Exhibit 3, my lord, family settlement, that doesn't give the boundaries. My lord.
Does it give the boundaries? So then, you having title over the land, you would be entitled to. Being a co-owner, you will be entitled to, unless there is no dwelling house. But you are not a purchaser, so you will be entitled to having a partition over that. You can very well ask for partition, but that, how do you get a degree for possession unless it is that aspect of them proved?
But
they have not denied the title, my lord. They said
Title you have. There's no quarrel. The court has also given you. The title cannot be given out here only for the purpose out here because that is already does not have been identified. Unless you don't identify that, yes, this is the trade. This is for the revenue authorities to do it. And did you ask for a partition? There,
because I said that partition has already happened. I said that mutual partition has already happened.
mutual partition as regard the shares has happened, but not the area.
But the schedule and everything, my lord, which I have given in my plain, they have not denied it. They have just stated that I have relinquished my share, although there is no relinquishment deed. And secondly, they have stated that my father has sold my share because he wanted to give some.
Now, how does the first appellate court deal with that and say that that schedule is not a part of it? It means has not been identified.
The appellate court has held that, my lord, since the complete 17 acres of land that has not been partitioned, so I cannot claim 3.5 acres of land. Because
There the problem arises.
that is-
Because how can you give it unless there is a revenue partition?
But the court could have very well given a partition. If it comes to the finding that there was no partition, could have very well given the specific share. Or had sent as per section 54.
No, court has already held that you are entitled to 3.5
3.5
acres.
acres.
But if you have not asked for
Then
partition,
it could have issued.
how? Tell me. It is on the volition when you want to partition. Isn't that the law? Then how do I help you with this? Next week.
That is how.
Please the matter again on 12th of June. Next week there are more matters. There's a 12th of June.
Deeply obvious.
Next week?
So the appellant was defendant, my lord. So the.
Mr. Chauhan, next week? Or this week? You want to do it or next week? Because if I take it, if there you have a good case, then you do it.
My lord, I think I have a good case.
Then later on, don't say. Because you see,
Patient, my lord. One, my lord, not including necessary party. And second, my lord, by limitation under Article 65 of the Limitation Act. Admittedly, suit was filed after 23 years. For
From?
recovery of possession. After 23 years.
from
From the date of possession. In their case, plaintiff case, that I was in possession since 1995 and suit was filed in 2018. So 25 years. And my lord, limitation issue was there, issue number 3. That was not at all discussed, my lord.
where is your plaint?
My lord, plaintiff mean, my lord, I was defended.
Where is your plaint? Where is the plaint?
Plain, my lord, in fact, 2 plaintiff I enclosed, my lord, because earlier one suit was filed, my lord, before the deputy commissioner, because there was no separate judiciary in the.
Is this the plaint? Page 19 is the plaint?
Yes, that is the plain. The second plain.
We are concerned with this plaint?
Yes, yes. Continue.
Suit was filed in the year 2018.
15.
Okay. Then
And my lord, kindly see, my lord, paragraph 4 of the plain. During lifetime of the Chitra Ranjan Acharji, father of plaintiff number 1, 2, 3, 4. In the year 1995, father was the defendant Gokul Das and
so it is permissive occupier.
Their
So-
claim permissive.
How does adverse possession come into the picture?
I'm
Let
not-
us see your, let us,
I
huh?
am not claiming.
Then how do you bring 65?
Lord, because my lord,
At the request of the counsel for the petition, appellant matter stands adjourned to be listed again on 14th of June, yes. Don't spoil the time.
Lordship, this case is conducted by senior counsel, Mr. TJ Mohantam.
Who?
TJ Mohantam, the senior counsel. Today he is not available due to some problem. And moreover, my lord, the service of the respondent number, defendant number 2 has returned, my lord, because.
What
the
are you
office has been changed.
challenging?
Office has been changed, my lord.
Mr. Ali, what is he challenging? And that
Unnecessary
day, another matter, Mr. Ali, you are nowhere to be found.
Unnecessary application is filed only to delay.
Forget about that. Unnecessary application. You appear whenever you feel like. There is another matter yesterday or day before yesterday. Nowhere to be.
In this case.
In that case, it is another thing. When your name is shown in the cause list, why you don't appear? Huh?
Brief is with him that side. Brief was with Mr. TG Bolo.
I am not concerned with that. Name is shown, you people should appear.
Finally, peruse annexatory application. Lordship will find that.
What is
Yes.
this case about?
Lordship, my case is for declaration of right title interest, cancellation of sale deed, recovery of possession. Accordingly, defendant contested the suit and issue were also framed on deciding right title interest, cancellation of sale deed. Lordship, what happened? After 2 years from the date of framing issue, they filed annexatory application. Lordship will find at page 247 for rejection of the plan.
Why?
Only on the ground and as builder is the party, the matter ought to have been adjudicated before RERA. Lordship, my prayer is under section 34, declaration of right title interest, under section 31 of specific relief act for cancellation of deed.
Cancellation of?
Cancellation of deed, sell deed. And recovery of possession under section 5 of specific relief act. Learned trial court also issues frame. Now, after framing issues,
Yes. How is it?
not at all maintainable.
Case is conducted by senior counsel, Mr. TJ Mohantam.
So, senior counsels are what? Senior counsel, do they have a tag on these matters? Are you saying that? The senior counsels have some interest in these matters. We only understand the senior counsels are only engaged for the purpose of the day-to-day matters. They are there for this matter only. You may not be there. Get hold of another senior counsel. I would have understood your difficulty, not the senior counsel's difficulty. And this is, I have been repeating, I'll put a loudspeaker out there next time.
It may be adjusted.
For what? Your difficulty. Your difficulty, not your senior counsels. Name? Mr. P.K. Bordloy submits that he has not prepared the brief properly today. Accordingly, matter stands adjourned.
Lordship, I may be allowed to take steps on the respondent.
Not required, Lordship. Presence of respondent, other respondents is not required.
Not
I was
necessary.
the plaintiff in title suit.
Don't worry. I'll fix it on when I come back. And on that day, we'll dismiss it. No worries. Not prepared today to do the matter as Mr. So-and-so, the learned counsel submits that he is not prepared with the matter today. Accordingly, matter be listed again on 19th of June 2024.
Hello.
What? Absolutely no.
Till the next.
No.
Till 19.
These type of orders are absolutely, and this is already vacated. List after 3 weeks, interim order shall be only till the next date. 3 weeks is over.
46.
Okay. Interim order shall continue till the next date.
19, my lord.
19/6. Yes, what is this? Union of India. What are you doing with Union of India?
This petition was preferred, Lordship, by Union of India, challenging the order by which the arbitrator refused to accept our objection file under Lordship will find the.
What? Arbitrator what?
The respondent was interested with a work for augmentation of water supply in the cantonment area. The bid value was more than 26 crore. He raised a dispute. Initially, it was referred to the dispute DRB, that is Dispute Redressal Forum, Board Lordship.
What objection did you raise?
Basic objection was that as per GCC 70 lordship, arbitration can be referred only after the work is completed or terminated
So on the jurisdiction,
and
on the jurisdiction.
or
So your
or
objection is on the
willingness also,
Huh?
lordship. It should be, there should be a written willingness. lordship. These are the three
readiness.
conditions for referring the matter to arbitration.
So you say that the arbitrator did not have the jurisdiction?
Because of the work is not complete and neither terminated nor lordship, we are willing to refer the matter to arbitration.
So this is, you filed an application under section 16, no, section 16? Challenging the jurisdiction of the arbitrator?
Not specifically stated, but
Then what is your
Under-
recourse?
under objection.
What is your recourse? Recourse cannot be 227?
lordship, whether 226 or 227, because
No, nothing. Recourse is not there. You have to go through entire proceedings till you may challenge it in the
lordship,
34.
that's true, lordship, but one of the judgment, lordship. I just went to place lordship.
Where? Judgment
Of this honorable court.
No. Show me a Supreme Court. Because the Supreme Court is clear on that.
Clear on that, lordship, but it says in exceptional circumstances.
Supreme Court is clear on that.
Yes, lordship, the most of the cases now, no, there should not. be
Supreme Court
recourse.
says that 34. Because you see, when there is an arbitration clause, it is none the business of the court.
That's true,
Because of
lordship.
section 5.
That's
It is
true,
not
lordship.
the business of the court.
That's true,
Sorry.
lordship. But in lordship,
Hello.
Punjab Agro Industries, this is also Supreme Court judgment. May I just read, lordship?
Yes, what does it say?
Paragraph 6 and paragraph 8. lordship.
Yes, what does it say? Is it so? Yes.
May I read paragraph 6, lordship?
This is of 2008. Things have,
Lordship, there's another lordship. 2020 lordship, 2022 also lordship.
show me that. Yes, what does it say?
Paragraph 17 onwards. lordship.
Hmm?
Read
Era?
Paragraph 17, lordship. In any case, the hierarchy in our legal framework mandates that a legislative enactment cannot curtail a constitutional right. In Nivedita Sharma and so, this court referred to several judgment and held. Lordship. That part when we skip, lordship, I am reading from, it is therefore prudent for a judge to not exercise discretion to allow judicial interference beyond the procedure established under the enactment. This power needs to be exercised in exceptional rarity wherein one party is left remediless under the statute or a clear bad faith shown by one of the parties. The high standard set by this court is in terms of the legislative intention to make the arbitration fair and efficient. So, lordship, in my Hubman submission, the exceptional circumstance is that they have engaged a counsel to appear on their behalf before the arbitrator, lordship. Lordship, the deep industry is also quoted here in lordship, paragraph 18.
Not necessary. Read paragraph 20, 21 and 22.
Lordship, our
Okay,
objection to
21.
another
20
objection-
no, paragraph 21. Read it.
The High Court did not appreciate the limitation. That's true, lordship. There is
No,
doubt about
paragraph 20, the last line.
that, lordship.
If the court, first, that is why, this is
If
the
court is
process.
allowed to interfere with the arbitral beyond the ambit and enactment, then the efficiency, the process will be diminished. There is
Then,
requirement that-
then 21.
21. The High Court did not appreciate the limitation under the 226 and 227 of the Constitution and reasoned that the appellant had undertaken to appoint an arbitrator unilaterally, thereby rendering the respondent number remediless. However, a plain reading of the arbitration agreement point to the fact that the appellant herein and actually acted in accordance with a procedure laid down without any malafide. So, lordship.
Then,
I
next.
fully agree with you.
No, next.
Respondent number did not take a legal recourse against the appointment of the sole arbitrator and the others submitted themselves before the tribunal to adjudicate on the jurisdiction issue as well as on the merits. In the situation, the respondent one has to endure the natural consequence of submitting themselves to the jurisdiction of the sole arbitrator, which can be challenged for an application under section 34. Lordship, that's true. There is no quarrel. But the other aspect is, Lordship, they have appointed an
What do you
counsel
want? Dismissal today or some other day
some other day, Lordship.
after vacation? No stay.
My
No
lord.
stay. There's a stay?
Yes, my lord.
No,
Our proceeding is
there
pending.
cannot be a stay. No. Stay I have not given it. That is why.
Yes, yes.
On 24/5, when the matter came up before, I said list the matter today for dismissal.
Yeah.
But today he wants another date, but I'm not going to extend. And the earlier interim order was only till the returnable. Mr. B. Chakraborty, learned counsel appearing on behalf of the petitioner, seeks for further accommodation, list the matter on 22nd of July 2024. Yeah, you take this judgment. This is a summer recess helpful for you. Bharat Construction through authorized. Yeah. This is your judgment for dismissing his petition.
My lord.
Give it, take it from
Yes,
me.
my lord. Thank you. Thank you. My lord, this arbitral proceeding is not being continued because of the stay order. There's no direct order to continue, my lord. So some observation in that line, my lord. But at least it can be started, my lord, because time limit is also there, my lord. Observation, my lord.
This court also takes note of that there has that post that on 24/5/2024, this court did not extend the earlier interim order. Accordingly, this court is not inclined to extend the interim order which does not exist. I know. That is enough.
May proceed with, this arbiter can proceed with, my lord.
Shall continue.
Yes, my lord, shall continue because he's.
Then we should adjudicate 227.
Correct.
That's not our business.
But the response side is not. State Bank of India is the respondent. In order is at page 13.
State Bank of India is there, no?
File them understood for revoke.
This is matter pertaining to, they have not appeared.
But if they have not appeared, look.
Give it to this person now, this Pervez. What is his name? He's a lawyer. He appeared for some State Bank of India.
I'll try to communicate.
Huh?
I'll try to
Give it to him. This the matter again on, we'll have it after vacation on 15th of July 2024. On 19th of July 2024, 24. Most of the interim order passed earlier shall continue till then. As the respondents are not represented, the learned counsel is directed to serve a copy upon Mr. What is his name? Ratipa Luciano Pervez Puli Koshil.
I'll try to correct his name. I'll try to correct his name and give it to.
Huh? Asil no Ratipa.
Hello, 13 orders.
Yes.
Lordship, respondent number 1 and 2 died. So we filed the substitution application, setting aside abatement and section 5 application. All are so office to dated 29/5, it reveals that says some defective. So I will be allowed to correct the defect, Lordship.
Mr. R.K. Bhuyan, the council submits that some time may be granted for correcting the defects in the interlocutory applications in terms with the office note dated 29/5/2024. List the matter. When
The date may kindly be given, my lord, because
list the matter, list the matter by on 14th of June 2024. In the meantime, the defects be removed.
All right.
Yes, what is this?
Against the order dated, your lordship, passed by the RCT.
No, no, you could not serve it. No service. What to do? Then old matter, why you are not being able to serve it? What matter is this?
Appeal against the order passed by the RCT, Railway Claims Tribunal.
Then what to do? NJ Gogoi,
PN Gogoi.
BN Gogoi. Mr. BN Gogoi submits that he would file, taking into account the office note dated 29/5/2024, he would file appropriate application seeking substituted service upon the sole respondent. List the matter upon filing such application.
Actually, I'm not pressing the second appeal. They were entering into some sort of understanding.
Mr. S.P. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the parties have already amicably resolved their issues, and as such, the appellant herein would not like to press the instant application for condonation of delay. Accordingly, the instant application for condonation of delay is therefore dismissed on withdrawal. The consequential effect of withdrawal of the application for condonation of delay is that the judge is that the accompanying second appeal, which is yet to be registered, filed against the judgment and decree dated 13/8/2018, entitled Appeal number 6/2015, cannot be entertained as it had become barred by limitation.
It pleases your lordship. Lordship, this is an IA for condonation of delay. You will recollect on the subsequent occasions the petitioner remained absent in this matter, lordship.
Why did he take it away?
Pardon.
It is seen that the applicant herein are not represented on various dates, that is on 24/4/2024, 1/5/2024, and 13/5/2024. It is also seen from the office note dated 29/5/2024 that the appellants have also taken back the defective IA numbers 1023/2023, IAC number 1021/2023, and IAC number 1022/2023, and have not returned those files. Accordingly, therefore, it is therefore apparent that the instant application, that the applicant herein is not interested in the instant proceedings. The consequential effect is that the instant application for condonation of delay is therefore dismissed for non-prosecution. the consequential effect of the said application, the dismissal of the condonation application seeking condonation of delay is that the judgment and decree is that the accompanying appeal filed against the judgment and decree dated 12/7/2018 passed by the learned additional district judge Gwalpara in title appeal number 12/2012 cannot be entertained. Adeka appears on behalf of
Respondent one.
On the last occasion, your lordship directed the registry to put the name of respondent council member A.R. Korim.
It's been shown,
No, my lord.
not shown.
That is why the
Take Mr. Saxon. This court had specifically directed by the order dated 23/2024 upon the registry, have issued direction upon the registry by the order dated 23/2024 to list the instant matter by showing the name of Mr. A.R. Karim. However, nothing has been, however, today when the matter is listed, the name of Mr. A.R. Karim have not been reflected in the cause list. The registry is directed to list the matter on 19th of July 2024 by showing the name of Mr. A.R. Karim. Yes, what is this?
Today,
How much?
are supposed to come, my lord, but natural calamity, they could come, my lord. Edge of the road, not come, my lord.
Who could not come? Why?
Reply affidavit.
Huh?
Reply affidavit. Affidavit given by the respondent number 4, my lord.
My lord, kindly see the order dated 6/5/2024. My lord, this is the matter where mother along with her 3 children sold the land by obtaining guardianship certificate, my lord. Thereafter, my lord, mother along with her 3 children filed title suit, my lord, before the learned trial court, my lord. But suppressing this fact, my lord, one of the daughter filed this petition before this honorable court, my lord.
My lord.
I have filed my objection enclosing the plaint of the WS, my lord.
Yes, why haven't you filed? Your objection is not on record. I to record it. You have filed objection?
Yes, my lord.
They also say that there is no objection.
On
Mr. A.H.M.R. Chaudhary submits that the objection was filed on
last Saturday, my lord. 24, my lord.
on 24/5/2024. However, the same is not on record. List the matter again on after vacation.
Okay.
List the matter again on 22nd of July 2024. In the meantime, the applicants would be at liberty to file their reply by 18th of July.
The office number is 29/5/24.
Service not complete upon response. What do you do?
Maybe awaited, Lordship, because we have taken only.
Abated?
Awaited. Maybe awaited. Service. report may be
Awaited. Okay. Why? When did you take steps?
Taken, Lordship, on, in the earlier occasion, we have taken through districts, district.
When did you take
now
steps?
Yes.
When? How much time?
Taken steps on, Lordship.
Okay.
We have taken steps on 21/3/24.
The registry shall place the instant matter before the Loziba court. And the counsel for the appellant shall do the needful in terms with such orders that may be passed by the Lozima court.
First of all.
What is this additional affidavit?
But we wanted to place on record a certain document. Because we have very recently received a mail from the company.
Huh?
They are doubting the accident, happening of the accident. And there are certain documents which I have asked for from the company.
How do you place it?
But we have received one.
Now, how do you place it?
I'll place by way of a petition, my lord, under 41 books.
Why it has not been filed?
Could not my lord, substantiate the.
So then,
I have received it now. Some more time. Otherwise, I have received the PV extract, but I do not.
I would not give you anything. You want to file, file. That's it.
My lord.
Taking into account that the LCR has not been received, list the matter after, list the matter only upon receipt of the LCR for the court.
On.
For the Lorema report, my lord, service is complete. $25,400.
Service is complete.
Yes. Complete. Now 24/5. 2024 as
IA for what? Delay?
IA for delay.
How much?
23 days. 823 days.
Okay. Taking into account the office note dated 24/5/2024, the service is deemed to be complete against the respondents. List the matter again on 19th of July 2024.
What should be returning on 19th? Is again returning on 19th.
Me? No, I'm coming on 14th of June. This is 19th of July after vacation. No urgency.
No, LCR not receiving this case.
Although the respondents have appeared on respondent numbers as filed.
The service upon respondent number 2 is not complete.
Yes, sir. One has appeared.
As per the office note dated 28/5/2024, the service upon the respondent number 2 is not complete. It is also seen that the LCR has not been received. The registry shall take necessary steps as regards the LCR. As regards the respondent number 2, the appellant is directed to take fresh steps by way of registered as well as usual within 7 days.
Public.
Same type.
Same, my lord, I have delay will be, my lord, 338 days, and my lord, LA reference case is different.
Hey, এখন order pass করে দিব।
Hello,
Application in the law. काम है अपना लोग का। Same order. ये तो खाली 338 ना?
38 and LA reference case number 19/13.
19/13.
Yes.
Again, same judgment.
Same. Paragraph also same.
disposed.
My lord, against that judgment, there are 14 cases in this court. So it may be ordered to be, all of them to be listed together for convenience, my lord. Because at different times, the same cases are coming up in different courts. So for convenience, they all may be tagged together and listed. That would be very convenient.
Mr. Bachchaji, first let it be registered.
After admission, that can be done. The lawyers are also same, my lord. He is also for railways.
And has appeared on behalf of the parties, so matter stands adjourned to be listed after 2 weeks. Yes, what is this? You're sleeping? What is this I for?
For
25 to do. I for what?
my footland now. Footland now, where two slopes are standing there.
You file your affidavit.
Yes, Lordship. Lordship, he has never been in possession of the last woodland or the rooms, and there is
Say
no
repairing to
shop is running, Lordship. Otherwise, also, Lordship, the LCR has received, and it may be fixed for hearing. As per the office note.
what repairing you want? What type of photographs you have introduced?
My lord, this is the soap, my lord. My lord can, second photograph, my lord can see there.
Second photograph, what can you understand? Nothing is there. Appeal of which year? 2013.
13, Lordship.
Okay. Taking into account, this is an application filed by the applicant, who is the appellant in the instant proceedings, taking permission for carrying out necessary repairing of two shops standing on the Schedule B land.
Lordship, there is no shops. There is no shops, Lordship. She has never been in possession of the shootland or of the rooms, Lordship, standing there.
EDB appearing on behalf of the respondents
Lordship.
submits that there is no shops
Shop.
and the applicant is not in possession of the
Shootland, Lordship.
of the
It is
shootland.
still in the possession of the respondent.
This court have taken note of that the matter that the accompanying second appeal is of the year 2013. And as such, an early disposal of the said second appeal would resolve the issue involved in the instant appeal, instant application. Accordingly, this court directs the hearing of the second appeal on hearing of RSA number 214/2013 on 25th of July 2024. I stands disposed.
Lordship, in this matter, LCR is received and service is complete. Finally, matter may be fixed.
Service complete, LCR received. List the matter for hearing in its usual course. Liberty, however, is given to the parties to file application for early hearing. Yes.
My lord, as per office note dated 29/5/24, respondent
LCR
number,
has not been received.
respondent number 2 has received, but so far respondent number 1, it is yet to be confirmed.
Okay, the service as regards the respond number 1 is yet to be completed. And further, the LCR is yet to be received. Under such circumstances, this court would await service and further direct the registry to take effective steps for requisitioning of the LCR.
28.
Yes, what happened? Got the money?
Lordship, I got a report from the MST one regarding the disputed amount. MST one informed me that MST one could not trace out after verifying the statement of different banks accounts of this tribunal.
Then,
Not trace out.
then, no, from your account, does the money go
And that's what.
to whom?
We have deposited the DD before the MSCT one. Then we could not trace out.
Now, how does the MSCD pay to the claimant?
So MSCT account.
Yes, you deposit, how can I get that?
Yes.
So there is no record of the MSCT paying it to her.
Yes.
So under such circumstances, you have to pay to her. Deposit the 50,000 when?
Within 7
days.
June.
What? Okay.
17.
Lordship, it will be 65,000, your Lordship. With the interest, it will be 65,000.
Can I give some relaxation, Lordship?
And I finish it off 50,000. Because that will again become another contest. Pursuant to the order passed by this court on 13/5/2024, it has been brought to the attention of this court that the amount of rupees 4,79,353 have already been received by the petitioner. However, as regards the disputed 50,000 rupees, the learned counsel, Mr. G.C. Bora, for the learned standing counsel for KSTC, Mr. G.C. Bora submits that they could obtain a certificate from the presiding officer, MSCT member MSCT 1, to the effect that there was no clearance of DD bearing number 581936 amounting to rupees 50,000 dated 6/4/2019. The said certificate is kept on record and marked with the letter X.
X is there.
X is one, I think.
X is there. It will be Y.
X how they call you? X, Y. It will be Y, na? Taking into account this court inquired with the learned counsel appearing on behalf of the ASTC as to when the amount of rupees 50,000 will be paid to the petitioner, taking into account that the petition, there is no records to show that the petitioner has received the said disputed 50,000. The learned counsel submits that the said amount would be paid on or before 14th of June 2024.
What's it, 17th pending?
Why 17? I fix it on 17th. 17 is a holiday. You want to pay on a holiday. 14th is the last working day on that week. 14th. List the matter again on 19th of June 2024.
Dispose of loss.
No, I don't trust.
I will pay definitely.
I don't trust. This is a case of mistrust, isn't that?
Can you read him us for that statement? Can you read him us for that statement?
What? No. I would have otherwise in other cases. This is a case where I trusted the ASTC council, and ASTC council said that only 50 or 41,000 to be paid. And he went out there, and now we find out how much. Now it is 5 lakhs.
About 5 lakhs.
Yeah, this has come out. Till the last occasion also, they are disputing on 50,000. You never know. Because then I have to close it.
Like,
Ira money.
Service is complete, my lord, as per office notice, 29/5/24, my.
The service is completed. List the matter. In course, liberty is given to the parties to mention for filing appropriate application for early hearing. Same.
No, it's a different lawsuit. It's a basically fell down case, lordship.
It's okay. Whatever may be, this is also service is complete. Ege agor order to. 30 na?
30.
Same order. Agor to.
One.
Yes, tell me.
Last order was regarding the pending from the alleged.
The question is this. Can there be a pre-trial decree in respect to a schedule D land?
I found one, in one case say that, in two cases, two cases I found that. Even if it is found that, when if the order goes to so that it is presumed that it may be a decree pre-trial, even then, if a situation, proper situation is there, in that case.
No, did you ask for that? Did you ask your entry through the schedule D land? Is it your prayer?
My prayer is.
Your prayer is only for recovery.
My prayer is regarding my right of way. Right of way.
Understood. Your prayer is for recovery of schedule D land because you say the schedule D land is your land.
Is in the plain, my lord. Right of way.
But there is no mandatory injunction.
There was no
No. Otherwise also, is there any mandatory injunction to the effect that you want to go inside the schedule D land? No. Your mandatory injunction is on another aspect. They have constructed on the basis of a interim order, in spite of a status quo order being passed, they have constructed and thereby they have, now you are not in a position to go inside. That is your case. But that is going through the schedule D land. You have never asked that you should be permitted during the pendency of the suit for entering into the schedule D land.
Actually, my prayer is for right of way, more my way. Just.
No, your right of way is there on the side.
What has happened, my lord? They have blocked my way. Right of way. My house, I can show you know what, how they have done it. How they have done it, I can show your lordship. What is the model operandi, how they have done it.
Mr. Sharma, I have full sympathy to you. But the problem is how you have dealt with in the trial court. I have full sympathy. Wouldn't it be better for you to amend your plaint and ask for that relief somewhere? If you don't do it, you will be in trouble. More particularly, you have not properly defined what is schedule D also.
That is one aspect of another order. But considering the overall situation, court can at least grant me right of way over there and up to my house. They have blocked my house. And what the 1996.
That would be pre-trial decree.
Even that is why there I am there I am there I am there. In 1992 SCC, Torab Kawasi Pardon, 1992. say that say that relief or interlocutory mediation are granted generally to preserve or restore the status quo of the last uncontested status, which proceeds the pending controversy until the final hearing when full relief may be granted, or to compel the undoing of those acts that have been illegally done or the restoration of that which was wrongfully taken from the party complaining. But since granting of such injunction to a party who fails or would fail to establish his right at trial may cause great injustice or irreparable harm to the party against whom it was granted, already not granted.
Today I allow you to use the right of way. Just for example,
That is right of way.
tomorrow your suit is dismissed. What happens? He files a suit.
That is the thing. That is what court said. Yes, said that balance of convenience has to be shown. Your lordship is not giving me entire land. Entire schedule D land is not given to me. I have given right of way that I can enter into my house. Presently, what has happened?
That is a question which should have been asked before the trial court. That is not a part of your
Trial
question.
court has, while passing the judgment, trial court has addressed the issue. Although it is
Trial court have presumed to the effect that you have did not consider that. Only I came to learn after seeing all these documents that there was a schedule. This is actually the road goes and falls into the schedule D land, and therefore now the problem arises because of you. What is the trial? Because you see, Mr. Sharma, let us assume that the trial court has passed that order for breaking. Can you be permitted to use that schedule D on the basis of that? Tell me. No, that is his land.
the trial court
As
said
of
that-
now, it is in his possession.
That is what, my lord. One thing is that the injunction, the mandatory injunctions are of two types. Firstly, one may be to restore the status quo as on the date of filing of the suit. And sometimes it can even be granted to restore the status quo which was prior to filing of the suit.
Prior to filing was, but it was not prior to filing, it was on 22/8 this happened.
Prior to filing of the suit,
You filed the suit in 510.
510.
So much, 2 months before. Just before, you see the words used. As on the date on which.
After a few weeks, after 2 weeks, 3 or 6 weeks. After 2 or 3, 22nd, they have entered into my land. Thereafter, we have filed the suit on 5th of the October when they started to construct one wall. When they started construct. Till then, we think that we can enter the land.
No, it is your categorical statement that you did not use. You did not go to your place from 22nd.
28, 27, wife of the petitioner had stated that I was inside and they have blocked my
Understood.
way.
On
They have blocked
22nd
my
it happened. 22nd it happened, I understand.
Yes.
But thereafter you have not used that. You filed the suit on 510.
My lord,
So as on the date of the uncontested status, if there is a change thereafter, then it's a different thing. But the status changed on 22/8, and that is not your prayer for you going inside.
my lord. Regarding my lord, that I get from you. Regarding the order passed by the trial court has said that the opposite party, that the petitioner, said that it will be decreeing the suit. So trial court said that demolition of boundary wall and allowing the right of way does not mean that the suit is decreed. It is a interim order. Trial court said that does not mean the suit is decreed. That is the finding of the trial court. But I can understand your lordship that your lordship want to say that in the plaint there is no prayer of mandatory injunction that I
Not
should
only
be
that,
allowed
where is your prayer to use the schedule D land? Where is your prayer to use the schedule D land? What they have done is that you have only got the first portion, the door, but not the house.
My lord, if we go technically, that is only thing.
That is the only thing.
If we go technically,
Because
my lord,
this would amount to pre-decreeing the suit.
if we go technically, my lord, that is one thing. But if we go by the gist of the thing, that I want right of way. My right of
But
way,
that is never your case.
my lord, in my application, my lord, my application may kindly be seen, my lord. My application may kindly be seen, my lord. Mandatory injunction.
Let us see your application for mandatory injunction. What does it say? Yes, Annexure C.
Is number 223, my
Page
lord.
number 223, page number
Exercise
223.
6.
So, sir, there is very there. And be further please to grant add interim mandatory injunction, remove the structures and open up the right of way for free movement of the petitioner to his vehicle for ingress and egress and to the building standing over the scheduled B plot of land, part of which is part of scheduled lane, A lane. And upon hearing the party may please to make add interim injunction absolutely. So I paid for a right of way upon scheduled A lane and scheduled B lane.
And what has happened to the the temporary injunction application?
Pending.
It is pending.
What is the order
To maintain status quo
as regards
regard the suit land.
possession?
No,
I-
nothing, my lord. To what respect is status quo is given?
The latest.
That is nothing. Only status.
Now, if there is a status quo order, can you pass a mandatory injunction now, giving you the right of way?
The order of status quo. Mother. Yeah, you are directed to send the copy this one. 610. Order 610. Further, considering nature of this, the court finds that there is an attempt of construction made over the suit property.
So your right to way, which must have been understood by the
And
trial
if
court,
any
is
permanent
this, that the right of way was from that, what you call the NH highway. There was a road which has been made. Till there it was okay, but it enters through the Schedule D land. That is the problem.
So, the status quo is granted, considering the fact that they are going to make construction, they are going to make construction, etc. That is, for the considering nature of dispute, the court finds that there is an attempt of construction made over the property by both the parties if the any permanent intention or construction or compression.
Let us see the what is the order passed in that section mandatory injunction application.
So status quo is not a blanket status quo. If it is blanket status quo, there will not be violation also. Right.
This is wrong. Mr. Sharma, can't help you. Do one thing, not today. Let's fix it on 12th. Before any other court, who will be there? Will be better if he may understand it better. But for me, it is very difficult because the right of way, one has to understand that the right of way is through Schedule D land. And that court did not understand. I would have understood a wall being constructed where you have the right of way from there. It's a different thing. But this aspect have not been clearly mentioned that the Schedule D is the right of way. This is the most pertinent aspect. If Schedule D is the right of way, then wouldn't it amount to allowing entering here? And this aspect of the matter, the trial court did not consider. On one hand, he is directing status quo to be maintained. And on the other hand, he himself says that in view of the violation of the status quo, I give you the right of way. How both will be there?
My lord, in para 40, that's why trial court also didn't say that through Schedule D you go.
Obviously, no. Whether the trial court understood that aspect, that it is through the Schedule D that he has a right of way.
That was not even
Because
the case
that
before the
problem
trial.
happens because the Schedule D has not been properly described. That Schedule D is a part of Schedule B.
That is part of Schedule B, that is apparent value. Of course, I understand that length is so much.
No, I understood only when I saw the photograph. Yes, Schedule D is there. Otherwise, it was such a small thing. What is there? Right of way. I was all along, initially I was thinking that it was a road which he has made, that is the right of way, and he has blocked that. He has that road. There is no blockage to that government road or whatever road. What they have done is they have carved out, and the way by which you are going, they have put it out there. So that is through the Schedule D.
Will be right of way will be the entire Schedule D, that is by land. The court will take into consideration that the Schedule D was my plot. It was my plot, and recently it has been taken.
Oh, that is a question to be decided in the trial.
That is another thing. But still, like that, my lord. My electricity is disconnected, my lord. After disconnection of electricity, I file a suit for mandatory injection. The court even allows me reconstruction of electricity. That is that was uncontested status. Electricity, that was before filing of suit disconnected, but the court has allowed me. So here also, I believe that I right of that. Otherwise my life is jeopardized. Entire life is jeopardized. I cannot enter into my home. That is a matter of that's a inhuman thing. That is very inhuman thing that I cannot.
You should have asked that kindly give me the right of way through Schedule D. That is not your claim. I think the trial court did not understand. You want, I can dispose it of giving you the liberty to file an application that you want to do it through Schedule D. Let the trial court decide. That is the only way out. In fact, Mr. Sharma, that is the only way out. I decided that I interfere with this order by giving you the liberty to file an application through Schedule D. Let the trial court decide. Because for me, you just think it. If you file an application here also, can I do that? Can I pass an order in this application? Can I file an application or pass an order to the effect that through Schedule D, you can go. I can't.
This part of Schedule B, that is why.
No, my lord, that is nowhere mentioned.
No, that is mentioned, that is apparent, that is apparent.
No, no, no.
Apparent?
I can.
How you
I
can say it is
go for-
apparent?
My lord,
No, my lord,
my
not
lord,
at all apparent.
my lord, may kindly see.
Four
What is
side
the-
boundaries is
No, no, no.
that was something else, my lord.
What
When
is
do
the-
you want it?
Next week, what?
Next week. Let it be on 10th. This is the matter. I civil number 1421/2024. List the matter again on 10th of June 2024. The interim order passed on 24/5/2024 is extended till the next date.
Obliged.
This is the appeal for orders on 10th of June 2015. Best way is that interference with this, giving you the liberty to move that.
That we can consider.
That is the only way out. Because once that aspect has already come to light, that it goes to Schedule D, becomes very difficult. Unless you get an order.
Yeah, the lordship. The lordship's order dated P5/24. I have the steps, the sea service also, my lord. 22, my lord.
Yes, affidavit in connection with Dusty has been said, learned counsel have entered appearance. Okay, very well. Now what happened?
They have already.
Oh, that matter.
Yes, my lord. Already appeared, my lord.
Hey, that day I passed an order, na?
Yes, my lord.
Same order types.
P5/24, my lord.
You have it?
Yes, my lord.
Fit. No. I've disposed of one matter, na? Similar.
Oh, my lord.
That was by Mr. H.R. Chaudhary or something.
Earlier-
Recently.
earlier one,
No,
my lord.
not very recently I passed an order.
Earlier one, I have earlier one, my lord, 99.
Exhibition at the order pass করেছিল। এই Supreme Court of 10/1/2022 করে দিছিল। Exactly same. Hidnata করেছিল। Mr. H.R. Chaudhary appeared. You know him? Exactly এটুকু ছিল। And the party should be directed to appear before the appellate court on 15/7. Dispose of কৰি দিব সেইটো এটা দিছিল নহলে এইখন আছিল খালি নম্বৰ কেইটা ইয়াত চাই ল'ব post.
My lord, in this matter, your lordship wanted to know whether the defendants would give consent to an extra chance for allowing the plaintiffs to adduce evidence. I have taken instruction, my lord, they are not willing to give any consent because of the long delay, since the matter is from the year 2015.
Is the plaintiff, na?
Defendants,
They are the
plaintiff.
I'm the plaintiff, your lordship.
Madam, sorry, can't help you. This is uh,
A humble prayer, very simple prayer before your lordship. It's my legitimate right, your lordship, to
Huh?
be heard. It's my legitimate right
For
for
what?
which I have filed this review petition to be heard
Yeah.
here in the court below. Because the trial will not be completed because evidence was not lead.
Trial not be completed. No, your suit will be dismissed. There is no trial completed. In fact, the court was good enough to give the defendant any chance to file evidence. In fact, on the very day the suit had been dismissed, unless there is an admission.
Then it will be a procedural fairness will not be reflected.
Why?
If evidence, if PWs will not be.
So, you have been given a chance. 10 days. Not 10 days. How many days?
More or less 10 days, my lord. 10 occasions. 10.
But those earlier dates has been recorded in writing. They have considered my petition, your lordship. Only your lordship come to the specific date. On which date?
No. Order 17 rule 1 says in a stage of hearing only 3 adjournments.
Yes,
Means every time 3, it will come out.
I'm not. But it's a legitimate right, your lordship.
There's
Otherwise
no
it will not-
legitimate right. No.
Because I'm the plaintiff. I'm the.
I can't help you. Sorry. Therefore, this is an application filed under section 114 of the Code of Civil Procedure seeking review of the order dated 1/4/2024 passed in TRPIO 322/2022. This court have heard the learned counsels appearing on behalf of both the parties and have also perused the records, perused the grounds on which the instant application is filed. This court is not satisfied that a ground for review of the order dated 1/4/2024 have been made out in the instant petition. Accordingly, the review petition therefore stands dismissed.
Must
Highly observed.
736.
Yes, what is this?
Application for injunction, my lord. The pending case, my lord, second appeal, my lord.
You've got an injunction.
And, there was a stay order. There was a stay order, my lord.
Then?
Granted by the court, my lord. Yes, in the past,
Why do you want the injunction?
because they have actually they have improved the land. They have started filling up the land.
We fill up the land only to resist the floods, my lord. We fill up the land only to resist the flood coming to the low-lying areas. We do not intend to construct any.
They filed your affidavit.
Affidavit has been filed.
What do they say?
They said, my lord, it was because of
The allegations regarding construction are false and fictitious, my lord.
there are 12, my lord.
Rather, there is no construction at all, my lord. Over the suit land.
So they have only filled up the land.
We have not done any construction and we did not intend to construct any. We did not intend. Rather, we are denying it. There is no construction at all. We just fill up the low-lying areas to reach the floods coming to the residents.
And what is the
And
order
regarding the-
passed?
My lord, regarding
There is
the.
an order of, there is any order?
No order was, but my only stay order was there.
What state?
Stay order,
Lordship-
because the
Lordship-
position was given to us, my lord.
Lordship, regarding the
There
annex.
was a decree of position handing over position to us by the appellate court.
Lordship,
So
regarding,
that order has been stayed.
But they have filed the RSA
But they have filed.
yes, we are appellants.
and they got a stay.
Stay.
And now they are constructing.
They were filling up the land, so we thought that.
Lordship, regarding the annexer 1 in the photograph, it is in the instant application, it cannot be ascertained as it relates to the suit land or not. It's only a vague part of it, they are citing it.
Because we made an application before the executive magistrate also. That is the-
It has been submitted by
My lord, regarding.
an application filed Under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure by the applicant, who is the respondent in the accompanying second appeal, number 27, RSA number, accompanying second appeal being RSA number 27/2021, alleging that the the appellants, who are the opposite party in the instant application, are raising constructions over the Schedule B land. It has also been alleged that there is a likelihood that the appellants may create third-party interest over the Schedule
We
B
did not
land.
intend to create any third-party interest. We did not create any third-party interest over there.
Schedule B land, which would be detrimental to the interest of the applicant, the respondent. On the other hand, the learned counsel appearing on behalf of the respondent submits that there is no construction being carried out. However, on account of floods, however, to resist the flood water coming inside the residence, some low-lying areas have been filled up without changing the nature of the suitland. He further submits that the appellants would not create any third-party rights or alienate the Schedule B land. Taking into account the above, this court therefore disposes of the instant interlocutory application, thereby directing that the appellants who are in possession of the suitland shall not raise any construction over the Schedule B land. Further to that, the appellant shall not also create any third-party rights over the Schedule B land. Be that as it may, this court, however, makes it clear that filling up of earth on the Schedule B land in order to resist flood can be carried out by the respondents, by the appellants. However, no equity can be claimed on the basis thereof. But no construction.
No.
My lord, file and my lord substitution petition.
Huh?
Substitution petition.
For what?
Not substitution petition.
Within time. Within time?
I have no objection. Actually, it is not substitution petition. President Secretary of the President and Secretary of one organization has expired. So that has been filed. The new President Secretary, name of the new President.
This is under Order 22, Rule 11.
Yes. So there is no limitation.
Rule 10, my lord.
Huh? Rule 10.
So
Last time also directed us.
I have
Right.
no objection in allowing the petition.
Only to President Secretary.
The 22 Rule 10. Who died?
My lord, President and Secretary, my lord.
Of
Of this, the Shomiti.
respond number 8.
Response number 1 and 2.
Respond number 1 and 2.
Yes, my lord. President Secretary of this committee.
Madhav Kolita and Santiram Kolita.
My lord, my lord. Substituted by Bhavan Chandra Thakuria, my lord, President, now
at present.
This is an application under Order 22 Rule 10 of the Code of Civil Procedure 1908 for bringing to the attention of this court that during the pendency of the instant appeal, the respondent number 1 and 2
Yes.
to the appeal,
President Secretary.
who were only arrayed as party in the capacity as the president and secretary of the respondent number 8
Hello.
had expired, and a new set of president and secretary have been appointed in lieu of the respondent number 1 and 2. Taking into account that the original respondent number 1 and 2 were only impleaded in the capacity of being the president and the secretary of the respondent number 8. This court, in exercise of the powers under Order 22 Rule 10, read with Order 1 Rule 10 of the Code, strikes out the name of the respondent numbers 1 and 2 and impledes Sri Bhoben Chandra Thakuria, son of late Dhareshwar Thakuria, President, Panitema Gaon Sabha, as respondent number 1, and Sri Dhiren Chandra Kolita, son of late Siddhiram Kolita, Secretary, Panitema Gaon Sabha, as the respondent number 2. The appellant is directed to, counsel for the appellant is directed to file a fresh memo of parties before the registry of this court by 6/6/2024. Why? You are going to do it?
By hand.
No, by hand. Type out properly. Not by hand. What is hand? You file it before registry, the registry will do it. You know. And the registry shall, on the basis of the fresh memo of parties, shall make necessary correction in the records as well as also update in the CIS.
39, 30 also same.
Huh? Another application. Same
That
application.
is the two by appeal.
Same.
Same.
Numbering of respondents, number of respondents will be
It will be different.
File
2 and 3.
It will be 2 and 3. Name is same.
Same. I number is 1314. In RSA 95 will be 2010. Only the difference is the 2 and 3. Much obliged.
9.
First time. First time.
First time.
Huh?
First time. Respondent number 1 expired, Lordship, and appeal was abated, Lordship, first occasion.
Oh, we have to issue notice. All 3 applications. 3 applications.
Yes.
Okay. You are appearing for?
Respondent number 1 who expired, Lordship.
You?
He's with me, Lordship.
Okay. Sole respondent.
No, there are other respondents.
Others are appearing for others.
Others. There is perhaps service not completed in main appeal. Perhaps service not completed in main appeal, Lordship.
Okay. Okay. Issue notice. Issue notice steps within 3, returnable 6 weeks, steps within 3 days, registered as well as usual.
Obliged.
Appraisal, Lordship.
Only substitution
Only substitute.
within time. Who died?
Respondent, opposite party, in cross objection. I am respondent in the appeal, second appeal.
Appellant died,
Appellant
Lordship.
And you have not filed.
Lordship, we have recently received the document. We have recently received all the documents, Lordship. We will be filed by Monday, Lordship.
Let it come up on Monday, Tuesday. Together it can be done. Now, if she files an application, then automatically, if that is allowed, your thing is gone. Because you are filing a cross objection, no?
Yes.
Miss
M. Nirola, Lordship.
M. Nirola, the learned counsel appearing on behalf of the appellant submits that that the appellant is also, learned counsel submits that the sole appellant had also expired and appropriate steps are being in the process of being taken. List the matter again on 7th of June. You'll find that. First time. First time. Who died? Appellant. Appellant number 1. You are appearing for all respondents.
I have all the responses from 1 to 8.
You have objection?
I have not received the copy.
Verbal limitation to notice.
Therefore, I am asking him. No, this is only he. If he is appearing for everybody, why notice should be given?
I have not received the notice. The copy may be served to me.
Oh, you have to serve it to him only. Because it is appellant, na? Therefore, Mr. S.R. Gogoi appears on behalf of all the respondents and submits that no copies of the applications seeking condonation of delay, setting aside of the abatement, as well as for substitution of the legal representative has been served upon him. Mr. H.J. Sharma, the learned counsel, submits that due steps would be taken, service would be duly meted out during the course of the day. Mr. S.R. Gogoi, the learned counsel, submits that 4 weeks' time may be granted for filing the reply. So, accordingly, this court fixes the instant application and this একদম ওপৰত এটা লিখি দিব হা ইস্যু নোটিছ তাৰপিছত তেনেকে SR Gogoi কৈছে হা তাৰপিছত accordingly list the notice SR appears on behalf of the so and so and submits that he has not received here. Accordingly, he shall serve during the course of the day, and therefore there is no requirement for issuance of any notice. Formal notice. তাৰপিছত সেইখন কৰিব এইটো দি list the matter after the summer recess. Notice steps by registered as well as usual within 7 days.
In this case, Lordship, I am praying for release of 50% of the awarded amount.
What awarded amount? RSA?
No, Lordship, MFA.
40? He give RSA লিখিছে তখন এটা কি করেছে যে MFA amount paid
Deposited, Lordship.
how much?
3,96,620.
Yes, why you have not got it?
There is no release of Lordship.
The LCR has come and service is complete. Also, the matter will fix for hearing also.
There is no other work, there is no other MSc matters in the courts to do the hearing so early.
Yep, liability against the liability also.
How many there are a lot of IAs. What are those IAs?
Lordship. One is
One is conversion, delay was condoned.
Those are done. Delay condone.
Therefore,
Uh-huh.
appeal was admitted and stay was.
An application for withdrawal of the amount of rupees
3,96,000.
3,96,620. Which have been deposited by the. This is an application filed by the claimant for release of the amount of rupees 3,96,620. What does the award say? How the payment is to be made? Award. It is
Awarded amount 7,93,140. With
Okay.
interest at the rate of 12% per annum from the date of accident.
Is an application filed under the filed claiming release of the amount of rupees so and so 3,96,620, which was deposited by the appellant on 23/8/2023. Taking into account the grounds which have been mentioned in the said application, this court is of the opinion that the said amount be directed to be released in favor of the claimant. Accordingly, this court therefore directs the registry to release the said amount of rupees so and so to the claimant, subject to making proper verification.
By furnishing bond lots.
Proper verification, subject to furnishing and subject to proper verification and to the bank account of the claimant.
Lordship, 5 claimants coming here, Lordship.
Huh?
5 claimants.
To the bank accounts.
Claimant number 1, wife. Claimant number 2, son. 3, minor son, minor daughter. 4, minor daughter. 5,
Mother.
mother.
And 6.
6,
The owner of the vehicle.
Huh?
owner of the vehicle.
Okay, no. Now, who are the claimants? Applicants are these. Okay. Be released to the bank account of the applicant number 1 and the applicant number 5 in the ratio of 80:20, subject to furnishing the indemnity bond by the said applicants number 1 and 5. Well, the mother also should get something. But yes,
Yes, I for continuation of delay.
notice skips. What is this 48?
On the last occasion, my lord point out the maintenance of this MFA. My lord, since the appeal is admitted on 15/7/2015, I am be allowed to file one conversion petition.
What?
Conversion.
Why?
My lord, on earlier occasion, my lord point out that why we not The application under Article 227. We have challenged the order file where my suit was dismissed. Dismissed on the application filed by the defendant under Section 8 of Arbitration Act.
What to do?
Sometime allow some time to file conversion.
File what?
Conversion application.
Converse to where?
CRP.
CRP, how can you do? Means 227.
27.
How can you do 227?
Then my lord, proceed with
There is a reason why I'm saying you can't do 227. Because 227 is against interlocutory orders. Quarrel with that. But by this order, the plaint has been, suit has been dismissed. Suit having been dismissed, on the ground that it has happened like this, then what will happen? Appeal does not lie. Where is the order of dismissal of the suit?
Lordship. Page 53, 49 to 52. 49. 53. 53.
Okay. Page 53 is, where is that order? You have only enclosed the miss case. What about the suit? What happened to the suit?
Start from 55, Lordship.
This order. Suit is dismissed. So if the suit is dismissed, that amounts to a decree. If it is amounts to a decree, wouldn't you then liable to pay? Wouldn't then you have to file a first appeal?
Lordship, that suit was for recovery of dues.
So, isn't that amounts to a decree? A dismissal is also a decree. Isn't it?
Then this MFA will proceed, Lordship.
No, MFA is different. MFA is different and RFA is different. MFA is miscellaneous first appeal. That is actually against those against which those from statutory appeals which lies. Just for example, the Railway Claims Tribunal and all this. But in that case, if you have to go by this, either you have to file a RFA in 15 line. Because the suit is dismissed. Because if order 7 rule 11, order amounts to a decree. When a suit is rejected, plaint is rejected, it amounts to a decree. And the suit has been dismissed, being not maintainable. For whatever reason. In that amount to a decree.
An appeal line. An appeal will lie.
Think about it. Just telling. Earlier, 115 used to be also filed against that order. But because of the fact that 227 doesn't lie. The reason you have 227 doesn't lie is if that application which has been filed, no, this is filed by other side. And this will be a decree, so you have to file an appeal. Appeal, you can convert it, but subject to payment of court fee, I suppose. Court fee you have to pay. This is filed within time.
This MFA is filed within time.
So you have to pay the court fee. How much is the suit valuation?
58 lakhs, 59,600.
You have to pay this 11,154. You have to pay that court fee. Then only this will happen. But what has happened to your this thing? And why didn't you go for arbitration?
My lord, the contract order did not reflect any arbitration clause. My lord. If I not come to the contract order, this was contract order, lordship. I'm the sub.
The learned counsel appearing on behalf of the appellant submits that the appellant would file an application for conversion of the instant MFA for regular first appeal. Further submits that for that purpose, he seeks some time. Also, when there would be a necessity of paying the court fee. The matter after the summer vacations.
Highly appreciated.